How much time can you do?
Please drag that mic. You make use of mic.
Yeah, case in the lower court has been stalled by an order of this court unless until I seek the permission of the committee before the Senate.
Correct.
So I have sought the committee's permission. So I'm filing the
Committee has
memo.
given permission to you?
Yeah, yeah, given.
Third, next week.
My lord,
22nd, 23rd, my lord.
23rd?
Yeah.
23rd. No, already many matters are posted. Even if I post that, it may not reach.
Or
Take some longer date, on the other date. But
next week, Monday, my lordships.
it all depends upon how matters are posted. Otherwise, which place you are from?
I'm from Bangalore only.
Then you will come,
Outskirts.
in the first week of February. Yes, Berkeley. Yes.
my lord, I am the petitioner, my lord, in this matter. It's a fresh matter, my lord. It's the impute order is from order of DRAT, my lord.
DRAT.
Directing.
Next week, according.
My lord, they have directed us to deposit a wrong amount, my lord. My lord,
Yes, what the matter? Within what period to be
my
deposited?
lord, 27th is the date to the next date in DRAT. My lord, may I have it tomorrow or day after, my lord. It's my humble request.
27th, you said, no? Before one day we can take. 2 days. Saturday we have sitting. Thakodi.
My lordship, it's my humble request that this may be posted on Monday because on 5th.
Possible because we have already many matters here that day. It
Because
will
of-
not reach only.
Because on 5th February, my matter before the trial court is coming up.
Therefore, in the 4th February, we'll have that.
Lord,
Ah,
FSL report given by animal husbandry graduate considered by the court below and is in hurry to dispose the appeal. So.
On Monday, we can have that one. It's pending matter, GMCPC. How it comes before us? With the division bench. It has to go before single judge, na? Yes.
Two companies are litigating before 3 arbitrators. Now, a guarantor who stood as a guarantee to raise a loan on behalf of one of the companies is sought to be dragged into the arbitration proceedings based on the Constitution bench judgment in Cox and Kins, that group of companies concept. Now, I was only a guarantor throughout. I have absolutely no role to play in the performance of the contract, the rights of obligation. Now, out of the 3 arbitrators, majority of the arbitrators held that these have to be dragged into the arbitration proceedings. The matter is posted day after tomorrow. So I sought for. Yes.
Yes,
By lordship's permission, my lord, serial number 38, may I seek for a short accommodation?
38. Call
38.
Call
Oh,
in the
that-
second week of February.
Your Honor,
39 mil, that's
39 also?
39 my lords, 39 my lords.
You
I
want
sought
time?
some clarification, yes, my lords.
All right. Same. Same.
43, madam.
43.
43.
You want time?
Yes, 2
Ah,
weeks.
2 weeks.
My lord, serial number 3, my lord.
Please wait. You are online. We have to treat people who are personally present here. Yes.
Your Honor, for WP 24623 of 24, it was supposed to be listed in second week of January 25. It was not listed in the last week and the
Got it.
before.
Yeah, one memo kodi.
Kindly get it. If you give me a date, I'll put the date in the memo and I'll hand it over.
Memo kodi, date ನೋಡ್ಕೊಂಡು ಹಾಕ್ಬಿಡಿ. ಆಮೇಲೆ ಅವ್ರಿಗೆ
Next week,
it's not possible in the second week of February. Yes, next.
Your Honor, if a
Don't
specific
take-
date is given, I'll put it in the memo.
We'll give you. Date kodi, other on February. 11th of February.
11th of February,
Serial number 26, a small, short accommodation to be given.
23,
26, Your Honor,
26, ಯಾವ year?
for the respondent bank. 20.
2020 matter. ಕೊಡ್ಬೋದಾ?
ಕೊಡ್ಬೋದು ಥರ್ಡ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ
Third week of February.
ಫೆಬ್ರವರಿ
Ah,
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಮೇ ಬಿ ಎಕ್ಸ್ಟೆಂಡ್
Call in third week of February on the request of, at the request of signs.
Madam,
Interim
serial
order
number
to continue
37.
till next date of hearing.
Serial number 37, madam, just a short accommodation.
37,
Yes, ma'am.
25 matter. 37, 2016 matter, brother.
No, madam, it's an official liquidator appointed. Companies under liquidation, just have to ascertain some detail.
All right.
Short up.
Call week after next.
41 my lord,
Request of
41. I just served a copy of the appeal paper to the respondent, my lords.
41.
41 my lords.
Now 4 years are over now.
Yes, my lord. I mean,
2 weeks at the request of.
Madam, serial number 40, madam. We were
41.
informed by the revenue council that some copies
I-
were not served. Serial number 40, madam.
I just mentioned 41 my lords.
That's what.
40.
Yeah, 41.
Serial number 40, madam.
40.
40, madam. We've informed that some copies were misplaced, madam. I've given copies today. May be taken up 2 weeks up.
All right. Call after 2 weeks.
Yeah, Your Honor, just one update on the WP.
Don't
The
waste
the
time.
2
Next,
months notice was given.
call this matter in April. Get that, note. Yeah. Next.
Serial number 28, my lords, the matter is rendered infructuous, my lords. The parties have
20.
settled the matter. 28, my lords. Maybe
Number
the-
heading,
Serial number, WP 6724 of 2024, my lords.
Barkali. Learned counsel appearing for the, you are for the petitioner,
Petitioner, please, my lords.
appearing for the petitioner submits. And that is not controverted by the other side. That an amicable settlement has been arrived at. And therefore, petition be disposed of as having become infructuous.
Please,
First,
please,
ordered accordingly and WP is disposed of.
deeply obliged.
Next,
My lord, serial number 3, my lords.
3.
3, my lords.
Huh.
My lord, this is the reallocated file. I'm appearing for the appellant number 2, 3, and 4. I
You want
kindly.
time?
Yes, my lords.
Call after 2
My
weeks.
lords,
at the
I'm for the
request.
respondent, my lords, in this one.
Do you oppose prayer?
I oppose the prayer, my lords, and also,
2 weeks they want. Will you?
Obliged.
Call after 2 weeks at the request of. No, ಅವ್ರೇನೋ ಹೇಳ್ಬೇಕು ಅಂತ. Have you served a copy on them memo?
yes, my lords.
Yeah. Next. Dispensed with.
ಅಲ್ಲ ಪ್ಲೀಡಿಂಗ್ಸ್ ಕಂಪ್ಲೀಟ್ ಎಲ್ಲ ಫೈಲ್ ಇಬ್ರು ಫೈಲ್ ಮಾಡಿದೀವಿ.
ಹಾ. Mr. Shankar,
ಡೇಟ್ ಕ್ಯಾನ್ ಬಿ ಫಿಕ್ಸ್.
date fix ಮಾಡ್ಬೋದಾ?
Short date.
ಯಾವ ಡೇಟ್ ಬೇಕು ತೊಳಿ.
ಮಂಡೇ ಮಂಡೇ
ಈ ವೀಕ್ ಆಗಲ್ಲ, ಬಹಳ ಮ್ಯಾಟರ್ಸ್.
ಕಮಿಂಗ್ ಮಂಡೇ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
ಹಾ.
ಅಲ್ಲ ಎಷ್ಟು
One day
27.
after next,
27.
3rd of February.
3rd February, my friend said he's going to Kumbh.
Ah.
No. ಇಲ್ಲ ಇಲ್ಲ.
No, most welcome.
20.
He told me,
In all fairness to him, he
Yes.
told me
How did?
27th is all right.
27th we have difficulty because
Then
371J is being argued.
3rd is okay. 3rd, my lord.
3rd of February. If there is any change, you can intimate also. ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಿಮ್ಗೆ ಅವರು.
No, my friend says, let it come in orders, we can finish it. I said, no, it will reach. It is a very old matter, it will be on top of the list.
Very. You should tell your friend that we should make order aste, whether it is in orders list or this one.
I know your lordship is too young, my lord.
Yes.
Your lordship prays for a week time, my lord. Better affidavit file ಮಾಡಬೇಕು.
1 week
Please.
for compliance of order dated 25/3/2024. Okay. Steps to be taken in respect of unserved respondents. Yes. The memo for clarification is adjourned. 4. Yes. Then.
With the,
ಏನಿದೆ?
one case, there's some delay also. I'm not-
ಹಾ. $435 days ಇದೆ. ಕಂಡೋನ್ ಮಾಡೋಣ.
ಮಾಡ್ಬೋದು. The only reason is, apparently, the reason given is advocate and commissioner disagreed on
ಅದು
what.
reason to be given by a private litigant and reason to be given by state and authorities, Article 12. ಅದು ಸ್ವಲ್ಪ ಕನ್ಸೆಷನ್ ಇಟ್ಕೊಳ್ಳೇಬೇಕಾಗ್ತದೆ. ಅದು ರೀಸನ್ ಏನು ಅಂದ್ರೆ ಅವರ್ ಕ್ಯಾಲೆಂಡರ್ ಸೆಡ್ ಲೈಕ್ ದಿಸ್ ಅಂಡ್ ದೇರ್ ವರ್ ಫೆಸ್ಟಿವಲ್ಸ್ ಬರೀ ಇಂಥದ್ದೇ ಇರ್ತದೆ. ಫೈಲ್ ಮೂವ್ ಫ್ರಮ್ ದಿಸ್ ಟೇಬಲ್ ಟು ಅದರ್ ಟೇಬಲ್.
Not that, but interesting thing is, advocate said no appeal, commissioner said file an appeal. That's the delay.
ಅಲ್ಲ, ದಟ್ಸ್ ಅಂಥದ್ದು that will put a dilemma. In fact, there is famous statement by Cicero. If ತುಂಬಾ ಹಸಿವೆ ಆದಂಥ ಒಂದು ಕತ್ತೆಯ ಮುಂದೆ 2 ಹಸಿರು ಹುಲ್ಲಿನ ಪೆಂಡೆಯನ್ನಿಟ್ರೆ ಅದು ಡೈಲೆಮ್ಮಾದಲ್ಲಿದ್ದು ಇದನ್ನ ತಿನ್ಲೋ ಅದನ್ನ ತಿನ್ಲೋ ಅನ್ಕೊಂಡು ಹಸಿವಿಂದನೇ ಸತ್ತೋಗ್ಬಿಡ್ತದ. ಆ ರೀತಿ ಆಗ್ತದೆ. ಅಟ್ಲೀಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ನಾಗ ಆಗ್ತದೆ. ಕಂಡೋದ್ ಆಗ್ತಿಲಿ ಯಾವ್ದ್ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಡಿಲೇ? ಎಲ್ಲದರಲ್ಲೂ ಇದೆ.
The first.
980.
matters ನಲ್ಲಿ.
Second one is.
In these intra-court appeals, delay is brooked. And for condoning the same, applications supported by respective affidavits are moved. First up, delay is bit longer, that is 435 days. as submitted by learned senior advocate appearing for the respondent is true. First off, however, we have matters which are older than these and all they are languishing in the cupboards of the court. First off, that apart, condonation of delay would not add merits to the advantage of the appellant and to the disadvantage of the other side. First off, a plausible explanation, of course, ideally speaking, comma, more plausibility was required, comma, is offered for the delay. First off. Next one, in view of the above, application is favored, delay is condoned. Same order you have to print in both the orders.
Second matter is already condoned. Second matter is already condoned.
ಒಂದೇ ಮ್ಯಾಟರ್
First matter ಮಾತ್ರ.
ಇಲ್ಲ ಎರಡರಲ್ಲೂ ಇದೆ
ಅಲ್ಲ.
ನೋಡ್ಕೊಳ್ಳಿ ಕಂಡೋನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡ್ಕೊಂಡು ಮಾಡಿ
ಎರಡು condone ಆಗಿದೆ. Second matter.
ರೈಟ್ ಹಾ
We heard the thoughts.
We are filing it during the course of the day. Number.
We have filed. We have filed.
ಫೈಲ್ಡ್ ಆಲ್ರೆಡಿ ಬಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬೇಕಲ್ಲ ನಮ್ಮ
ಹೌದು.
ಆಗ್ಬೇಕು.
Argument ಆಗಿದೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ ನಮ್ಮ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಏನು ಅಂತ ಅನ್ಕೊಂಡು
ಅಲ್ಲ,
It,
earlier court
of course
said-
we'll make use of that.
So the court said file written
File that.
submissions, then we'll hear it.
ಈ ರೀತಿ ಆರ್ಡರ್ಸ್ ಇದೆ ನೋಡಿದೆ ನಾನು ಹೌದು ವಿಚ್ ಡೇಟ್ ಯು ವಾಂಟ್ ಆಲ್ರೆಡಿ ನೋ
February 6th.
20 this week
ಅಲ್ಲ, February 6th.
February 6th.
ಹೌದು.
All right.
Thursday.
ಆಗ್ಬೋದಾ ನೆಕ್ಸ್ಟ್ ಹಾ ಹಾ ಇರಲ್ಗಿ ಸರ್ವಾಗಿದೆಯಾ ಹಾ
My lords, we have undertaken, there are a lot of respondents, my lords. We are yet to receive the wakalat, my lords. Kindly 2 weeks time may be granted.
Please.
ಮಾಡ್ಬೋದಾ ಅಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಇತ್ತು ಅಂತ ಹೇಳ್ಬೋದನು ಮತ್ ಸ್ಟೆಪ್ಸ್ ತಗೋಕ
ಅದೇ ಇವ್ರಿಗೆ
steps in respect of answered respondents to be taken.
Yes.
First,
My lord,
service of papers is
My lords, we,
on counsel appearing for
uh,
respond number.
Lord,
Now
serial
respond.
number 5, respondent number,
Now respondent is made,
my lords,
full stop. Srimati so and so appears for the said respondent and she seeks time to file the wakalat. ಯಾವ್ದು ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ ನಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ಬೇಕು
My lord, in the first matter,
Yes.
they are for
my
1
lords.
to, my lord,
1 and 2.
1 to
1
12.
to 12.
1 to 12.
Yes.
Huh? 1 to 12.
Ah.
13 is the state of Karnataka. 13, 14.
1 second. ಸ್ಟೇಟ್ ಯಾರ್ಯಾರಿದ್ದಾರೆ ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹಾ ಬೇರೆಯವ್ರಿಗೆ ಅನ್ಸರ್ಡಿಗೆ ತಗೋಬೇಕು ನೀವು
Unserved, my lords, government agencies.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ
State
ಅವರೇ ತಗೋತಾರ
house.
State, I'll take notice for all minutes.
ಅದೇ ಹೇಳಿ ನೋಟಿಸ್ ತಗೋತೀರಾ
My lords,
Ah,
state
let the
government, I'll
DTA.
take notice.
ಆದಿತ್ಯ on request accepts notice for other respondents. ಓಕೆ ಎರಡನೇದ್ರ 5.1 ದಲ್ಲಿ ಏನಿಲ್ಲ
R. Chandrasekhar and others. My lords, in that respondent number 1 to 24.
ಯು ಅಪಿಯರ್
Yes, my lords.
5.1
They appear.
so and so appears for response 1 to 24. ಹಾ
Then, my lords, CA Ramu and others, writ appeal 1599 or 23. In that, we are for respondent number 1 to 12.
1 to 12.
Yes, my lords.
ಅಲ್ಲಿ ತೋರಿಸಿದಾರಲ್ಲ 1 to 24 ಅಂತ ಹೌದು ಆರ್ 29 25 to 20 that's what
29 to 59.
Correct.
29.
25 to
29
29 not
Executive engineer.
EGAPS for 25 to 28 ಆಗಿತ್ತು steps to be taken in respect of answered respondents ಬರ್ಸ್ಬಿಟ್ಟಿದೆ
Government agency.
5.3
Aditya appears. my lords.
Huh?
Aditya appears.
For the state, I'll take notice.
Sri Aditya, learned AG on request accepts notice for answered respondents. Okay. Error appear ಆಗ್ತದೆ. Or 15 to
They have appeared.
R1 to R45.
Only R47.
Yes.
None. State.
ನೀವೇನಾ ಅದು ಸೇಮ್ ಆರ್ಡರ್ ನೋಡಮ್. ಓಕೆ. ಕೋರ್ಟ್ ಫೀ ಕೊಡ್ಬೇಕಲ್ಲ, ಸೆಂಟರ್ ಶುಡ್ ಪೇ ಟು ದ ಸ್ಟೇಟ್.
I'll pay. It missed my notice. I'll pay it.
Court fee to be paid.
Yes.
Yes.
ತಗೋಬೇಕಾ?
R1 to
Data
R1 to R9. my lord,
R1
my
to
lord,
R9
is appearing.
ನೀವಿದ್ದೀರಿ ಆಲ್ರೆಡಿ.
Right.
R13 to R37 ಯಾರು?
I can appear, my lords.
For all?
All, my lords.
Okay. Same order. Call after 2 weeks.
Lords, my appeal against the same order is listed on the 27th. I'll give the number to the.
Call these matters on 27th along with
I'll quote it.
They are seeking 2 weeks.
2 weeks time.
ಅಲ್ಲ
my
ಬಟ್
lords,
ಬರ್ಲಿಲ್ಲ
because-
ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದ್ ಸರಿ ಕೊಡೋಣ. ಅದು ಇನ್ನೊಂದಿದೆ ಅದಕ್ಕೆ. ಇಲ್ಲ ಇದನ್ನ 2 weeks ಮಾಡಿ ಅದನ್ನ ಅಲ್ಲಿಗೆ ಹಾಕೊಳ್ಬೇಕು.
ಆಗ್ಬೋದು.
Call after 2 weeks. Okay. Yes.
Grateful, my lords.
I'll a better affidavit, my lords, in 1 week. my lords.
ಎಷ್ಟು ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತೀರಿ? ಬೆಟರ್ ಅಫಿಡವಿಟ್, ಫಾರ್ ಬೆಟರ್ ಅಫಿಡವಿಟ್. ವಾಟ್ ಈಸ್ ದಿಸ್ ಹ್ಯಾಪನಿಂಗ್? ಇದಕ್ಕೆ ಲಿಮಿಟೇಷನ್ ಇಲ್ಲ. Other day, some Mr. Rao appearing for the assessee was telling, it is better to scrap law of limitation. And perhaps he is justified. Every time better affidavit ಅಂದ್ರೆ ಏನಾದ್ರು ತಮಾಷೆ ಮಾಡೋದಾ?
No, my lords.
ಇದೊಂದು ಸಿನ್ಸಿಯರ್ ಆಗಿ ಈ ಕಾರಣಕ್ಕೆ ಡಿಲೇ ಆಗಿದೆ. ಹಿಂಗಾಗಿದೆ ಅಂದ್ರೆ ನಿಮ್ಮನ್ನು ಬಿಲೀವ್ ಮಾಡ್ದಂಗೆ ಆಗ್ಬಿಟ್ಟದ ಗೌರ್ಮೆಂಟ್ ಅನ್ನು. ಹಂಗಾಗ್ಬಾರ್ದು. Call after 2 weeks for filing better affidavit finally. Yes.
Court fee has been paid today, my lord. The other complaints, I pray for 2 weeks' time.
Court fee is paid, comma, says the panel counsel. Full stop. But he assures that other requirement would be met. Call after 2. Then 4 times.
I will just file the, finally I will.
ಒಂದೆರಡು ಬುಕ್ ಕೊಡಿ. ಅಸೋಸಿಯೇಷನ್ ಲೈಬ್ರರಿಗೆ ಒಂದೆರಡು ಪುಸ್ತಕ ಕೊಡಿ.
Finally, I will do it, my lord. Within a week time, I will do it.
All right. 2 weeks finally.
Lords, I appear for the respondent.
GS on behalf of respondent 1. Nagharish GS. ಏನು ಮಿಸ್ಟೇಕ್ ಇದೆ? To address that mistake. Company seal is not there.
The respondent was a partnership firm, my lord. In 2023, it has been incorporated to
As a company.
a company. Either company.
ಇದೆ.
It has been.
Office objection being wrong is overruled. Okay, ಅದೇ ಸೀಲ್. In compliance of ಏನದು ಮತ್ತೆ ಬೇರೆ?
ಅಷ್ಟೇ. ಅದೊಂದೇ.
Yes, what is this matter?
No, that this other connected matters have been admitted, my lords. Let the matter be posted for admission. Yes, my lords.
Post for admission. But then if they are admitted, we'll admit now only. But again, why to post it again?
Because maybe my lord senior counsel is appearing on the other side. Maybe they wanted.
All right. Call after 2 weeks along with other connected matters.
Matters, yes, ma'am.
Okay. A list ಕೊಡಿ.
Please go.
List of which will
Yes,
be
ma'am.
furnished by the panel.
2 matters.
Okay. Next week ಹಾಕೋಣ. ಕೊಡಿ. ಅದೇ. ನೋಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. ಅಷ್ಟು ಅವಸರ ಮಾಡಿಕೊಂಡು ಅಲ್ಲೇ ಏನಾರ ಮಾಡಿಕೊಳ್ಳೋದು ಬೇಡ. ಹೌದಾ? Not maintainable in view of circular of 2016, 15-16. In view of CBDT circulars 15-16. Yes. This board of.
Circular number 9 of 24.
9 of 24. ನೋಡಮ್ಮ, circular number 9 of 2024 ಅಂತ ಎಷ್ಟು ಬರ್ತಾರೆ? Dismissed, rejected. Okay. Registry to send a copy of this order to the respondent SAC by speed post immediately. Next. Sanmati. 227 days. Office objections 5 times, 3rd time. ಏನದು?
Your worship, I pray for a week time, my lord.
All right. ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಸನ್ಮತಿ ಬರಬೇಕು.
I'm sorry, my lord.
Next. Non-compliance office objections, third time. Ajesh Kumar,
My lord, either legible copies furnished ಮಾಡೋದಕ್ಕೆ ಕೇಳಿ sir.
ಯಾವ್ದು legible ಇಲ್ವಾ ಅದು?
Annexure B, D and E and F.
ಕೊಡಿ ನೋಡೋಣ ಕೊಡಿ. ಮತ್ತೆ ನಮ್ಗೆ ಬರಂಗಿದ್ರು ನೋಡೋಣ. ಮತ್ತೆ ಅಷ್ಟಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟು ಹೋಗೋದು ಬೇಡ. ಮೂರ್ ಸರಿ ಟೈಮ್ ತಗೊಂಡಾಗ ಮಾಡ್ಲಿಲ್ಲ ನಂಗೆ.
ಇಲ್ಲ sir, ಅದು ಮಾಡಿದ್ವಿ. We have filed an IA for
Sir,
dispensation. It was
D, E,
rejected.
K. Our argument this so many. Typed copy.
Please.
All right, ಮಾಡಿ. There is
Lordship
a note.
recently has passed an order with respect to the same. This one.
Comply ಮಾಡಿ.
Please.
Comply. Post if compliance is done. Okay.
Please.
Manmohan.
Lord, the amended petition lot has been filed.
Translation dispensed with the. How? Dispensed with the. Non-amendment. Amendment ಮಾಡಿ.
Amendment file ಮಾಡಿದೀವಿ not. Amended
what
petition
side
has been filed, but other physical copy correction ಮಾಡ್ಬೇಕು. But there are several pages not which are added. Lord's permit, I will only mention that not amended as per court order and I separate its file.
ಕೊಡಿ.
Please.
Since amendment comprises of several copies of documents, papers,
Documents
of
and pleadings.
pleadings, come on. And a simple endorsement as to petitioner having filed the amended pleadings to be made in the original pleadings.
Great.
And that would suffice. Kodi. That has been done.
I shall do it.
ಈಗ
Right.
ಪಟ್ಟು.
ಈಗ.
But
Lord,
that is done in the open court.
Lord, can I seek a short issue, Lord, is only with regard to Lord. But we are all purchases of not site, not from the society. Arkavati layout. Lord, we were sent before Lord the Justice Keshanar committee. But the committee now says, Lord, I am not entitled for anything. From Lord, I am Lord, although Lord, the sale deed in my favor executed by society. Lord, now Lord, I am left high and dry. What has happened is Lord, society executed a sale deed in my favor. And Lord, there were disputes Lord between the landowner Lord who executed a GPA and agreement in favor of the society. On that basis, Lord, society executed not possession letter in my favor, executed sale deed in
But
my.
the transfer of title had not taken place.
So transfer of title, Lord, in sixth sense that Lord, the society Lord did not purchase the land, but there's Lord agency coupled with interest, and society executes the sale deed in my favor. And after the death Lord of the landowner, his wife confirms the fact that Lord, the society has interest in the property. And Lord, this is the issue, Lord. If Lord may kindly Lord, fix a date next week, Lord, I will argue the matter on merits.
My lords, what happened is petitioners are the purchaser from the society, my lords.
ಅಲ್ಲ ಒಂದು ವೀಕ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Yes, my lords.
ಮಾಡ್ಲಿ
Yes.
Week after one
But my lords,
Any date may be fixed, my lords. I request for a date, my lords, because
Madam is also asking for time.
please.
Is it not? You
Yes,
also want
ma'am.
time?
Yes, my lord, senior counsel is engaging in.
my lords,
this
because
matter.
why I am.
We'll fix a date.
Yes, my lords, matter.
Correct. Call this matter on. One date ಹಾಕಿ. Choose, pull down a date from the calendar.
My lords, or 28th or 29th, my lords. Shorter date, my lords.
First week ಹಾಕಿ. 3rd of February. no?
7th of February. So 7th of February.
7th of February.
Please.
Friday ಆಗಲ್ಲ. I will be in another bench, na?
Lords may have it on 6th, Lord, subject to Lord's convenience. 6th.
All right. 6th.
Much obliged.
Lord,
Okay.
the interim order would be extended.
Interim order to continue till then.
Please.
Much obliged.
Grateful, my lord.
The connected matter both are similar.
Same, ah?
ಹೌದು.
Yes, my lord.
ಇಂಥ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇತ್ತಲ್ಲ ಏನು ಬೇರೆ ನಾವು ಇನ್ನು ಮತ್ತೆ ಯಾವ್ದ್ರಾಗ ನೋಟಿಸ್ ಮಾಡಿದ್ದೇವೆ ಆಮೇಲೆ ಅದಿದ್ರೆ ಒಂದು ಕೊಟ್ಬಿಟ್ರೆ ಎಲ್ಲ ಒಂದೇ ಸರಿಗೆ ಮುಗಿಸ್ಬಿಡೋದು ಐಡೆಂಟಿಕಲ್ ಇಶ್ಯೂಸ್ ನೋಡ್ಕೊಳ್ಳಿ.
My lords, in so far as society is concerned, my lord, this is the one
This
matter.
society
Yes,
talk.
my lord. In so
Please,
far as,
my
my
lord,
lord,
Other society.
another one matter is pending, my lords. I will submit the case number, my lords, by end of the day.
Grateful.
Next.
my lord, if the BDA also may be directed to file their objections, my lord, in this matter.
How can court direct defendant to file the WS? We can take notice of absence of their pleadings and pass order. Let us see. We have no such power to tell a client to a litigant, no, you should file your objections like this. We cannot.
Yes.
He may choose in his wisdom not to file objections at all.
Yes.
Lords, appear for the petitioner.
Yes, Ashwin,
Lords,
how are you?
I have tendered my resignation to the Lokayukta institution, my lord, for personal reasons.
Is
My lord, kindly have it next week, my lord. They will make alternate arrangements, my lord.
ಯಾರು ಸಾಮಾನ್ಯವಾಗಿ appear ಆಗ್ತಾರೆ?
ಅಲ್ಲ, ಅವರು have given back the files, my lord. They will make
Call
alternate
after
arrangements.
2 weeks.
Please.
At the request of learned panel counsel, who states that he has returned the file to the local.
Yes.
Yes.
For the petition, that the
yes,
proceedings
that's
before the land grabbing prohibition court is challenging floods.
Hmm.
Floods, the earlier, the deputation of land is provided under section 2(4) of the act.
Well, notice note. The learned AG is requested to accept notice for ಯಾವ respondent ಗೆ?
All the
respondents. ಅದು ಕೋರ್ಟ್ ಅನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ.
ಅಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಮಾಡಿ.
ಅವ್ರು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Please,
latest judgment.
Please.
Petitioner to delete respondent number 4 from the array of parties. Full stop. Status quo till next date of here. Status quo ಪ್ರಶ್ನೆ ಅಲ್ಲ. Stay of intermodal ಅಂತ ಕೇಳಿ ನೀವು.
Further proceeding.
ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಸಮಸ್ಯೆ ಇದೆ ಇಲ್ಲಿ. ಆ ಕೋರ್ಟಿಗೆ ಇದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ
Further
ಅದಕ್ಕೆ.
proceeding.
Interim order as prayed for till next date of hearing. All right.
Yes, my lords, I may be permitted to file a objection, my lords.
Objection.
Ready, my lords.
ಅವ್ರಿಗೆ ಕೊಡಿ ಮತ್ತೆ ಒಂದು ಕಾಪಿ.
ಕೊಡ್ತೀನಿ.
ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ. ಯಾಕಂದ್ರೆ ಅದು ಏನೇನು ಇರ್ತದಲ್ಲ ನೋಡ್ತಾರೆ ಅವರು.
Yes, my lords.
All right. Call after 2 weeks. Condonation of delay 113 days.
118 days.
It can be condoned, my lords. My
Okay.
objection may kindly be recorded.
ನೋಡಮ್ಮ. Application in IA number 1 of 2023 supported by an affidavit shows plausible explanation, gives plausible explanation for the delay. And therefore, delay of 118 days is condoned. Okay, IA disposed of. That is all right. Okay, Toli, objection Toli. Condoned after noting the objections of the other side. Okay.
Oblige. Much.
There is short delay of 19 days, my lord.
19 days will condone. That is short delay. IA supported by affidavit, therefore is allowed. Delay condoned. Next.
Lordship, serial number 17 to 21 are connected, my lord. Sir, the copies today only to the other side, my lord. It may be taken up after a week, my lord.
All right. What is?
Pay for the respondent.
Call after 2 weeks. Call all these matters together.
My lord, after 3 weeks, because the file IA in all these matters for condonation of delay, we'll have to look at the papers, appeal papers. I've just received the papers in all of these.
Please just urgent.
Still, yes, 2 weeks.
Serial number 22, I appear for the petitioners, my lord.
You appear for petitioner. ಏನಿದೆ?
But let's kindly pass over the matter.
Pass over. Sorry, pass over. ಏನು ಬರಲಿ ಅವ್ರು ಯಾರು? Are you ready in the matter?
Yes. One of the private respondent is also there. Mr. Ajay Nandalike appears for them.
ಮತ್ತೆ ಅವ್ರಿಗೂ ಹೇಳಿ. We'll have this matter in first week of February.
Well, please, a date may be fixed.
All right, one date good. Call on so and so. Okay.
Well, it's interim order will be kindly.
Interim order to continue.
Great.
Continue till then. First.
Delay of 64 days, my
May be
lord.
condoned.
ನೋಡಮ್ಮ ಕಂಡೋಡು ಸ್ಟ್ರಕ್ಚರ್ ಮಾಡಾಕ. ಏನು ಕ್ವಶನ್ಸ್ ಏನು?
Issue of transfer pricing, my lords.
Identical matters were you want to look into?
Just 2 weeks, am I there?
All right, 2 weeks at the request of. Are you related to Will Gold Narayan Rao?
Please not.
You
Yes.
are?
Great grand father.
Oh, the great author.
Please. Udayavagali.
ಉದಯವಾಗಲಿ
ನಮ್ಮ ಚೆಲುವ.
ನಮ್ಮ ಚಲುವ ಕನ್ನಡ ನಾಡು. So beautifully written. DVG has praised him. Yes. Yes. ಕೊಡಿ. party ಅಲ್ಲ no? Yeah, for permission. Post after 2 weeks to enable counsel for the petitioner to come and argue.
Please, my lords.
Sorry, please. I've kept my file is misplacing it. Could be.
Or deliberately have put out so that you can ask.
No,
for-
no, minutes. I'm the last person to do it.
Next week, madam.
Next.
Call.
B group, my lords.
Already notice ಆಗಿ ಬಂದಿದೆ. ಯಾವ ಗ್ರೂಪ್ ಇದ್ರೇನು? There should not be any groupism in the court at all.
Sorry.
Call after 2 weeks at the request of Sinchana. Yes. Call after 2 weeks to enable counsel for the petitioner to come and argue. Continue ಮಾಡಿ. Fresh matter. Fresh matter ಕೊಡಿ. No. Counsel ಬೇಕಾಗ್ತಾರೆ. Call after next week to enable counsel for the petitioner to come and argue. Yes.
If I pray for 2 weeks, this is Supreme Court remand matter, the transfer pricing, my lord, I require to file the additional substantial question
2
of
weeks
law.
at the request of Sanmati. Mr. Rao, he wants 2 weeks. Can we grant that?
I leave it to my lords. My lords were hearing that matter from Mr. Chaitanya.
That we have to undertake hearing now.
So only
Chaitanya is
after that,
sitting
perhaps
here
this can be taken up, my lord.
Arithiman, that appears to be sensible.
After disposal of that case, all these cases will may be taken up, my lord.
That's what Mr. Rao is also saying.
Will be adjourned for 4 weeks.
Call this matter after 4 weeks will not be sufficient. 6 weeks. Since questions raised in this petition are being treated in other matters wherein hearing is halfway through.
Obliged to my lords.
This is, oh, lordship, this is also Supreme Court remand, but this may be admitted, my lord. One question of law is there, my lord.
Same question of law. Appeal is admitted on the following substantial question of law. First up, which reads as under. Okay.
Lord, appear for the appellant in this matter. My lord, this matter pertains to whether the respondent is entitled for exemption under section 11 and 12, my lord. The assessing officer has held that he is not carrying on charitable activity as per section 215 of the Income Tax Act.
Only charitable activities idra matra.
Please, which should extend to the general public, my lord.
No, that's all right. Whether these activities are charitable or not. It's a mixed question of law and fact.
Please, my lord. My lord, here he is the assessee is a milk producers cooperative society, my lord.
Correct.
Where they take donation from the members and extend the benefit to the members only, my lord. So whether.
How can that be? Suppose if profit comes and I share it only amongst the members of the group, can it be said charitable?
That is precisely why, my lord, the assessing officer has held that the assessee is not a charitable, he has not carried out any charitable activity, he does not come under the definition. But however, the CAT appeals and the ITAT has held that a general mutuality among the members
is charitable.
That's why, my lord, I have raised question of law 1, 2, 3, my lord.
Petition appeal is admitted on the following substantial question of law, which read law, question of law. Reproduce madbeka. All right. Page 10, 11 is note.
Next matter, same, different assessment here.
Same order. Yes. There is a very famous judgment. There are 2-3 judgments, very interesting judgments. One is Subhash Chandra Bose versus so and so. Subhash Chandra Bose, Mr. Chaitanya, great Subhash Netaji had filed that case under Trust Act. Another is Narayana Bhale Rao versus BG Tilak or something like that under law of trust. There are such judgments.
Look into
Just look into
it. Please.
Very interesting. And yet another is Annie Besant versus so and so, so and so. Most of them were argued by great stalwarts like P.B. Vacha, such stalwarts. Just look into please. And the identical question. Because such questions arise under section 92 of CPC. If it is a public or a charitable trust, then 92 is entertained. On that, there is 174 judgment of the apex court, 3 judgment decision. When it is charitable, when it is a public charitable trust, very beautifully articulated. Much of law in this country has moved from mutts and pontiffs, etc., including Keswananda. Yes.
The transfer pricing matter, my lord.
Question say another.
Page number 10, 1 to 3.
Nodama, 1 to 3. Issue notice. Yes.
Appearing for the respondent.
You appear. Shri so and so appears for so and so. Appeal is admitted on the following substantial questions of law. Okay.
34 also transfer pricing, my lord. One question of law in page number 8.
Nodama, page number 8. Notice ಆಗಬೇಕು ನೀವು ಅಪೀರ್ ಆಗ್ತೀರಾ ಇದರಲ್ಲಿ ಇಲ್ಲ 34 notice ಆಗು admitted on substantial question of law. Issue notice. Okay. Yes, Chaitanya.
Lords, fairly simple appeal. Questions are in page 21, Lords.
Yes.
Whether on the facts and circumstances of the case, the tribunal was right in law in refusing to rectify the mistake apparent from record. Whether on facts and circumstances, the tribunal was right in law in directing pro rata deduction under 80IB 10 in contradiction to its finding that the appellant is entitled to full deduction thereunder. If I may explain to my lords very briefly, there is something called 80IB, my lords, in the Income Tax Act. Subsection 10 of 80IB used to give tax holiday in case of housing projects.
Housing projects.
Housing projects, just to encourage housing. However, my lords, there are certain conditions. If these conditions are not met with,
No
the
exemption.
assessee would be denied the benefit of deduction. 2 conditions were brought in by Finance Number 2 Act of 2009 with effect from 1/10/2010.
110, not 114.
ಇಲ್ಲ 1/10/2010 ಇಂದ ತಂದು. Here 2 conditions are brought. In 80IB 10, clauses E and F have been brought in. The condition is that to ensure that this would go to the needy customers, if a house is allotted to a non-individual, not more than 1 house should be allotted in the project. If
So
it is
one single allotment it should be.
if it is a partnership firm company,
That way.
you can give one house. If I am the developer, I can't give to.
Then you cannot give it to somebody else.
Similarly, if it were an individual.
Like a 39 B and C.
Exactly.
Distribution of property like
Exactly. This condition did not exist earlier. It came in with effect to 1/10/2010. Another condition is, if it is given to an individual, then no other site no other plat in the same project could be given to the spouse of the individual, lineal ascendant or descendant of the individual, or if the individual were a HUF, or the allottee were a HUF, to any other member of the HUF. Lords.
A small question.
Yes, Lords.
What is difference between joint Hindu family and Hindu undivided family?
Lords. In so far as income tax is concerned, my lords,
HUF.
it calls it as Hindu undivided family where, my lords, the devolution would be by way of operation of law. Where, my lords, if a property is considered as belonging to HUF, Hindu Undivided Family, the share of the member would be decided by births and deaths in the family.
In accordance with personal law.
In accordance with Hindu law.
Hindu personal law.
Hindu
Yes.
personal law. Subject to certain caveats and the exceptions which are brought in by Hindu Succession Act, including what my lords would be aware of 2005 Act, where even
Correct.
a female member could now be a co-partner, which was earlier not permitted to. Under the Income Tax Act, my lords, this HUF is considered as a separate taxation unit and entity. Like how in USA, my lords, a wedded couple could be called as a single unit. Or under the Portuguese civil law, Comunio Dobans, where, my lords, husband and wife would be treated
Goa.
as
Goa.
Husband and wife would be treated as one single taxable unit.
Even in English law, till 1891,
ಹೌದು.
wife was considered to be part of husband. So if the husband manslaughtered or woman slaughtered wife, then it was no manslaughter at all. It was only half suicide, for which there was no punishment till 1891.
Lord, in fact, our laws, our customs gave a lot more respect to women than what was portrayed by the British.
Always. That's how our
We would
Smutikaras
call-
say.
We would call woman Adishakti.
No, not only that. Etra narestu pujjante, tatra ramante devata.
Exactly. And
yeah,
when it comes to income tax, it would call HUF as a separate taxable entity and would be eligible to be treated as if it were a separate assessee. In as much as, my lords, it would claim the benefits on its own. It can claim the rates of tax on its own.
It is an assessee.
It's an assessee by itself. It's an assessee by itself. And you have, my lords, various sections in the Income Tax Act which you deal with certain attempts by the taxpayers to keep on subjecting the family to partial partition and creating multiple HUFs, whereby, my lords, multiple entities could be created and multiple
more benefits.
lower slabs could be claimed. For which purpose Section 171 of the Income Tax has been brought in, which provides that the law, whatever be under Hindu law, there is no bar on partial partition. But under the income tax law, a partial partition would be ignored and it would be treated as if the family is not partitioned at all.
In other words, regardless of partial partition that
Under
is
the common-
permissible under the Hindu law,
Yes, my lords.
notwithstanding such partition,
Exactly.
it will be treated as if there is no partial
There is
partition.
171 subsection 6 and subsection 7.
It's only to ensure
And
that in the
subsection
case
9
of that, they don't get. It
Exactly.
may be true also, not necessarily fraud.
Yes, my lord.
Even if it is honest partition, still that will not be taken cognizance of.
Whether
by
it is
Income Tax
honest
Act.
or otherwise recognized by law or otherwise, so far as income tax is concerned, it would deem as though the family is not
united,
partitioned.
undivided.
And such family would continue to be assessed, my lords, as if it were never subject matter of partial partition. Likewise, my lord, if there is a total partition, if a family which has been assessed as HUF hitherto, then unless and until a claim is made that the HUF is partitioned, and the assessing officer in the course of proceeding records a finding that there is a total partition, even the total partition would not be recognized.
Oh,
This is
that's a
to ensure-
precondition.
Huh?
It's a precondition for taking cognizance of partition.
Exactly.
Okay.
And if many a times a family may have been partitioned, legally family would not exist, but assessing officer would not know. He would have gone ahead and passed an assessment order at the time when he passed the order, at which point in time, to recover the tax, Section 171 provides that every person who was a member of the family at the time of severance of his status
Becomes liable.
becomes severally and jointly
Jointly.
liable to the tax of the HUF, provided, however, that his liability is confined to the share that is allotted to him.
It cannot exceed that.
It cannot exceed. These are the provisions under the Income Tax Act. The questions that would arise many a times, my lord, says whether it's HUF property or individual property. For which, my lords, it depends on how the funds are employed for acquisition of a property. If the acquisition of the property is through the toil and the funds of the HUF, no matter in whose name it stands, as my lords would know,
It becomes the family
becomes
property.
the property of the family. This is about HUF.
Yes.
And joint Hindu family, which my lords have said, which in my limited understanding is a synonym for Hindu undivided family, insofar as income tax is concerned.
Yes.
Now, my lords, in this case,
You mentioned about policy, housing policy, promotion of housing policy,
Promotion of housing.
subject to conditions.
exactly. In the instant case, it so happened that, my lords,
No, you
that-
said two conditions,
Huh.
but you mentioned only one. That there cannot be allotment to more than one member that way.
in fact, this is a condition put in two different brackets, in as much as if my allotee is a non-individual, like if I would give it out to a company, I can't give more
corporation.
than one. If I give it out to an individual HUF, I can't firstly give it out another one to the
Spouse
individual.
or member
So
or
that-
lineal descendants.
Exactly. So these are the conditions. These conditions have been brought in prospectively from 1/10/2010. Now, my lords, what the assessing officer did is he noticed that there are a couple of cases in a project which had 100, 200 apartments. Assessing officer noticed that there are a couple of cases where there's a violation of these two conditions. Assessee contended that because these conditions were brought in with effect from 1/10/2010,
That are done hitherto.
Lords, I may be allowed to be standing myself corrected. It's not 110, it's 1/4/2010.
I felt like that. Therefore, I told
There
you.
are some amendments.
Anyway, it may be also, it's open to the parliament to make.
Yes.
the
They
even,
did, they did. This is
the-
1/4/2010. My friend corrected. Now, assessee contended before the assessing officer that because these flats were already allotted and agreements in respect thereof were entered into prior to 1/10/2010, at which point in time it couldn't have been envisaged that such a
law will come.
law would come. So assessee contended that the denial should not be made. What the learned assessing officer did is, look, because you have non-complied with this condition, even if you were to have done it in respect of one single flat, one single occasion, I will deny you the benefit in total. That's what the assessing officer did. But there is no difficulty on this. Assessee goes in appeal to the learned CIT appeals, who will endorse the view of the assessing officer. Then the assessee goes to the learned tribunal. Assessee takes twofold grounds. Firstly, that the disability is not at all attracted to me for the reasons that this amendment has been brought in effective 1/4/2010, prospective, and I've already entered into agreements with my customers.
How agreement will transfer the title?
It would not transfer the title, but I cannot also renege from my agreement. I would.
That left to you.
That's fine. I would come to that, my lords. That correctness or otherwise of this I'll come to. The point here is a limited extent as to what the tribunal said, which became final because the department did not challenge it.
Where is that?
Let me just complete if my lords would allow me to complete it.
I have understood the point now.
Now, there is one more point. Now I would come to the crux of it. The learned twofold arguments were taken before the learned tribunal. Firstly, there is no breach at all, because these were allotted prior to 1/4/2010, and accordingly, completely deduction should be allowed. The denial of deduction is incorrect, is the first ground. Second ground, without prejudice to the first ground, the assessee takes a without prejudice ground to argue that if at all you would say I have contravened, don't allow me the deduction in respect of those one or two flats. Are my lords with me on this? You deny it, not in entirety. This is the contention taken. Correctness or otherwise, my lords, my humble submission is, at this point in time, my lords may not even ponder over it for a while, because this requires. Now, what does the tribunal do? The error in the tribunal's finding is the tribunal says, by referring to the decision of this Honorable High Court Division Bench in Mandavi Motors case, the learned tribunal says, yes, this condition would not apply on a retrospective basis. Therefore, assessee is right in arguing that there cannot be any denial at all. Having said that, the mistake the learned tribunal did is to go on to say that, therefore, we will allow you pro rata deduction. So we went before the learned tribunal and this finding has become final. The department did not challenge it. So the finding that the assessee is eligible for the benefit, despite the fact that one or two of the units have been given in contravention of clauses E and F, would not result in denial of benefit for the reason that this amendment is prospective because agreements were entered into, transaction as such was entered into. There is no need for denial. This finding of the tribunal will become final.
We'll examine that also, but point is whether the policy enacted in the particular provision, which I'm not much aware of,
I'll take my last.
whether it presupposes conveyance or agreement to convey.
I will take my lords to it. I'll take my lords to all these.
Yes.
If my lords were to just give me one another minute, then what the learned tribunal did is, it while holding that I have not contravened any of the provisions, it mistook and went on to say that therefore I am eligible for pro rata deduction. Then we went before the learned tribunal to say that you have already
Full benefit.
because pro rata is only without prejudice ground which you have taken. When you allowed me the principal ground, where is the question of pro rata?
Will not go to that level at all.
Then the learned tribunal refuses to entertain the miscellaneous petition, and therefore I am before my lords. That's all the issue. Now I will answer my lords all the questions. My apologies if I were to.
Let us see the text of the law.
Yes, I'll take my lords. My lords, may kindly take 2024 Income Tax Act.
2024 Income Tax Act.
2024.
That 1/4/2010, that continues to be the policy all through
No,
till date.
it is no more relevant. It related to much earlier year, 2013-14. This tax holiday has had its sunset. Because it relates to the relevant assessment year, section continues to be there in the statute book. My lords, may kindly go to page 1.664. Which will lords will find it on the left-hand side.
664. Page number?
1.664. 664. Have my lords found that?
Got it.
On the left-hand side, at the bottom.
1.664.
Yeah. My lords will find the page number at the right-hand top corner.
1.663 ಸಿಕ್ತು. The next page ಹೋಗ್ಬಿಟ್ಟು 1.665 ಆಗ್ತಾ ಇದೆ.
Oh, I think there is an error in that book.
1.6. No, you are right. My brother is right. 1.664.
May my lords kindly go to left-hand side at the bottom, subsection 10.
Subsection, the amount of deduction.
This is the section, my lords. May I read this, my lords, for a while?
Once.
The amount of deduction in the case of an undertaking, developing and building housing projects approved before 31st March of 2008 by a local authority shall be 100% of the profits derived in the previous year relevant to any assessment year from such housing projects if. Then my lords will go into various subsections. There are various conditions which I'll not trouble my lords with that.
Now, why that is saying 31st day of March 2008?
Because my lords, they did not want this benefit to be everlasting. Because at some point in time, my lords, they will find that there is a need to encourage housing. They provide. This has been now substituted by one more section, which made this benefit available to much smaller houses. Because this was limited to 1,500 square feet. Now they have brought it down to 800 square feet. Then, my lords, you will have condition A, which will talk about when it should commence and when it should complete, which may not be the issue in the instant appeal, my lords. And now, my lords, may kindly see question B. The project is on the size of a plot of land, which has a minimum area of 1 acre. That means, my lords, it cannot be just a very small unit. It has to be on a minimum 1 acre.
The whole project should be in that 1 acre land.
Exactly. And it cannot be 2 houses in 1 acre. So the 2 big bungalows.
That also is split.
Condition C will address it. Residential unit has a maximum built-up area of 1,000 square feet and are 1,500. Then, my lords, D. The built-up area of the shops and establishments
1,500 will be applicable to you.
1,500 is applicable because it's in bank. That also there is no difficulty on that.
Yes.
Next condition is the
Built-up
built-up
area.
area of the shops and commercial establishments should not exceed, my lords, 5% or 5,000 square feet or whatever. 3% and 5,000 square feet. Because otherwise, my lord, they shouldn't put up a big commercial
After
mall.
1 acre, minimum 1 acre.
It has
if
to be
it is.
minimum 1 acre. It has to be a housing complex. In the housing complex, as my lords would see, there could be a need to have some commercial establishment like ATM, small mall, or whatever. That should not
be more than this limit.
more than 3% or 5,000
Of the
square feet.
aggregate built up area.
Whichever. Yes, yes.
Okay.
Then my lords will see E and F. Not more than one residential house
Unit in the
in the housing project is allotted to any person, not being any individual. My lords may kindly see the language here, allotted, not transferred or conveyed.
How allotted, word allotted is construed by the courts.
Typically in the industry, my lords, because the word allotment has not been defined, it has to be, my lords, understood.
I think there are judgments which have interpreted this word.
No, here, if I may humbly submit, my lords, in the context of income tax, because the word allotment has not been defined, my humble submission, my lords, which the courts also have endorsed, is that the allotment has to be understood how the business understands it. Typically, my lords, when my lords would book an apartment, what would happen, my lords? My lords will pay the booking amount and an allotment letter is issued along with an agreement, which is always considered as allotment. Why, my lords, am I saying this? That at times, my lords, a question, slightly off the track question, why allotment is important here is, at times, my lords, a question would arise as to how long have I held an apartment? Is it from the day it's conveyed to me? Or is it from the day it is allotted to me? A question would arise because my lords would know long-term, short-term, differential rates or whatever. Then, my lords, the income tax department issued, my lords, a circular number 571. I'll correct it, my lords, I could be wrong. In the context of Delhi Development Authority allotment of flats, where the CBDT clarified that even when the DDA, Delhi Development Authority, wouldn't even have identified which unit goes to Mr. Ravira, which unit goes to.
So once allotment is made,
they would have made an allotment letter on the basis of some lottery, first come, first serve basis. And the board has clarified in circular 571 that from that day you are considered to be owning it, and to see whether it's long term or short term will reckon from that day. And this circular of the board, contemporaneous expositio, this is how, my lords, the tax administrator also understands it. Which, my lords, in KP Varghese case 131 ITR 597, Honorable Supreme Court said that when there is a doubt about the interpretation of the taxing statute, it would not be bad to go on the principle of contemporaneous exposition as to how, my lords, the tax administrator would understand it, provided the understanding of the administration
coincides with the that of the assessee business people.
Exactly. And, my lords, it benefits the assessee. Department's assessing adverse to assessee would not bind the Honorable Court, because tax department is an adversarial party here. Is a party to the dispute. It may want to understand a particular term in its own way. So that's why, my lord, the courts have been saying the beneficial interpretation by the department.
In other words, what you say is this allotment need not be conveyance.
Exactly. Exactly.
It can be a letter of allotment.
Exactly.
How this question is treated by various high courts in the
country? This honorable court, this honorable high court, the division bench of honorable high court, my lords, in Mondavi Builders case, had already taken this view. This was followed by the learned tribunal. I did not trouble, my lords, because this issue, insofar as this particular matter is concerned, was not challenged by the revenue.
That finding remains.
That finding remains. Just to cut short, my lords, if my lords were to kindly go to paragraph 4. Paragraph 4, my lords.
Consider the submission.
Somewhere in the middle of that para, it starts with the words, in other words. Are my lords there? About 10th line from bottom. In other words.
In case.
In other words, in case a residential unit is allotted prior to 1/4/2010, the conveyance in such a residential unit can be registered subsequently also. And in such a case also, assessee will be entitled to benefit of deduction under 80IB 10.
Conveyance is not necessary.
My lords?
Conveyance need not have happened.
Exactly. Therefore, my lords, what the learned tribunal did, it rightly followed the jurisdictional Honorable High Court's decision and held that these conditions do not apply to me. Having said that, the
Pro
learned
rata.
tribunal ought
Could not have said pro rata.
This is all the error, which when was pointed out to the learned tribunal, it did not correct it, which compelled my lords, the appellant to come before my lords. This is all the issue.
I may be
Perfect.
permitted to take notice, let the matter be admitted, my lord, then posted.
Appears to be that. Simple.
It's very simple, my lords. Very, very simple. It could even be taken up at my lord's convenience anytime and we could dispose it in one hearing.
Perfect. The following, the appeal is admitted on the following substantial questions of law.
Lords will find it at
Erade.
page. Erade.
Page
Page
21. 21. First stop. Issue notice. Learned Senior Panel Counsel is requested to accept notice for the revenue. Yes. Call up to 3 weeks. ಮುಗಿಸ್ಬಿಡ್ಬೋದು ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ because ಆರದೇ ಸಾವಿರ judgment ಇದೆ. But the word allotment,
Lords.
of course, in the tax jurisprudence they have considered, but there are judgments of this court.
Lords.
What is meant by allotment? Because many titles flow, benefits flow because of allotment under housing schemes, etc., cooperative housing property societies regulations. Their courts have taken the view it is not just mere allotment. Allotment that would result into transfer of title in the subject property. There are such judgments.
In fact,
anyway, may not be much applicable.
What my lords have said would be absolutely right. In fact, the Honorable Supreme Court in Suraj Lamb's case, 348 year, page 1, dealt with all these aspects.
Suraj Lamb's
case.
Ravindran Sahib.
Justice Ravindran's decision. 348 year, page 1, my lords, where the Honorable Supreme Court dealt with various aspects and eventually held that unless and until it is conveyed by the process known to law, there is no sale in terms of section 54 of the Transfer of Property Act. At the same time, the Honorable Supreme Court in Suraj Lamb's case also considered cases where the genuine power of attorneys would have entered into for a consideration.
They were
and the rights that would flow, though it may not amount to sale, the rights that would flow would matter. However, my lords, for the purpose of income tax, because my lords have mentioned this, I may be permitted to mention two aspects in income tax. Income tax considers transfer in a much wider sense. What in the common law is not considered as a transfer is considered as a transfer. I'll give an example, my lords. Section 53 of the Transfer of Property Act. Lords, the income tax considers
also transfer.
Income tax in terms of section 2 within bracket 47 within bracket small Roman 5, which is regarded as a transfer. Then, my lords, one more thing. In 2 within bracket 47 within bracket 6 of the Income Tax Act, it says any agreement or any arrangement by whatever name called, which has the effect of, which has had the effect of enabling the enjoyment of the immovable property.
That becomes transfer.
That would amount to a transfer. Therefore, that is why I was trying to mention to my lord.
The idea of transfer is much wider than what it is under section 5 of Transfer of Property.
It's much wider.
Much wider than.
In fact, this has been the subject matter. This amendment came in 1987 with effect from 1487. And the circular number 495 of the CBDT explains why this has been brought in. And this has been analyzed by, my lords, 2 honorable decisions of the Supreme Court.
If the fictions are permissible for the legislature, for its policies. If it is open to the legislature to treat that the sun is very cool and moon is very hot. We will not undertake a scientific investigation of all that. It is a deeming that way. In fact, Dicey says English Parliament is so omnipotent. I'm using his words, maybe wrongly. He says a parliament can convert a man into woman and a woman into man for the purpose of legislative policies.
This is echoed in much sober words in Karmachari Union versus Union of India.
Correct.
Where they have said common sense and income tax. But at the same time, in Judge Gotla's case, the Honorable Supreme Court said, though the common sense income tax are strangers, it is not necessary that they should always be treated as strangers. If it is possible to interpret the law in a manner where it will appeal to common sense, that interpretation would have to be given. This is Judge Gotla's case.
Correct.
Honorable Supreme Court decision.
Some very witty
Yes, yes,
statements we find in some judgments. Thank you so much.
My lord.
At least I learned so much from you.
Obliged.
Yes.
My lord, may kindly permit us to file wakalatnama and come on record in this matter for
Okay.
respondents, my lord.
Admission. Admission ಇದೆ ಅದು. Admission ಆಗಿ ನೋಟಿಸ್ ಆಗಬೇಕಲ್ಲ ಆಮೇಲೆ ಬರ್ತದೆ.
Yes, it is coming for the first time, my lord.
ಹಾ, correct. Admission is a matter between court and the appellant.
My lord, a very interesting point.
Is it?
Every consumer should, my lord, be aware of this. Now, my lord, I am the manufacturer of cars. My lord, I'll tell my dealers, you announce a discount on these models. My lord, he announces the discount. My lord, I have to reimburse the dealer
With that differential.
How do I reimburse it? I announce a reduction in, my lord, the value of the vehicles, which are high-ended vehicles, which attract higher rate of duty.
A kind of fraud only.
The benefit.
But suppose if it is legally permissible.
No, it is not legally permissible. Tribunal holds in my favor on merits, saying that this cross-model utilization of discount is not allowed. It leads to undervaluation of the millet. Now, what happens is
who should decide the price of a commodity? Suppose I
generate. That is under section 4 of the Central Excise Act. My lord, the valuation rules are there.
They are there.
They are there.
Decided not.
My lord, I'll bring to my lords after the matter. That this is the, my lord, the issue. The tribunal holds that this cross-model utilization of a discount is not a trade discount. And the benefit which is passed on to the consumer is in respect of a different class of cars.
Not related
Not
to
related
this.
to this. So this cannot be called as a discount. Discount really, my lord, it goes to the benefit of the consumer. So, my lord, he offered reduction in a price in respect of high-end cars and spare parts of the high-end cars to reimburse the, my lord, the discount which is, my lord, offered by the dealer. This was the.
One second. Whether that reduction of price, does it take the price below the cost of production?
It may not be the, my lord, it won't.
I am entitled to prescribe. Suppose if I grow banana, which I do in my land, and I fix for each banana 500 rupees. Thereafter, we say its production cost is rupees.
You artificially have reduced the price so as to, my lord, reduce your tax liability.
No, if
but
I
you
want
have offered,
to
my lord, discount in respect of those.
I am asking one question. Which law regulates price fixation? Show that.
My lord, that is Central Excise Act valuation rules. As well as the, my lord, the.
You can't fix, you have no liberty to fix your own price.
No, we have there is a, my lord, mechanism.
Yes.
There is a mechanism. Tribunal holds that, my lord.
No, you said that. Now I am asking, is there any law which says the manufacturer of goods cannot sell his goods at a particular price? Or should sell goods only above particular?
No, not a particular price. It is not a particular price. It involves, my lord, cost of production, cost related, my lord, factors.
But I may
and
choose
I
to sell
some markup on that, marketing, etc., it goes on.
Niralgi.
Please.
Can I sell my goods at a price lesser than cost of production?
No.
You can't. Where is that? Read.
That's not there in the act, my lord, but that's business. This thing is.
Unless, see,
my lord, who will then, my lord, he will not be in the business next time.
Don't worry about him. Let him commit suicide. He will take care of his soul.
So this is the, my lord, the.
No, but.
Can you turn to, my lord, the paper book?
I am the producer of banana. I will prescribe what the price should be. My prerogative. It may be less than cost of production.
My lord, that price which he reduces should inure to the benefit of the ultimate consumer.
No, why?
Yes.
Why do you say that?
That's the, my lord, the purpose of discount. That's the purpose of discount.
Where is that?
Which is, my lord, that is not the other. That is, you will also make any, my lord, section It is discussed in the.
Suppose if I distribute cars at 50% of cost of production, which law comes in the way?
My lord, the transaction value, if it is fixed for a particular period, for a particular transaction,
Who fixes it?
my lord, they fix it according to the valuation rules. There are rules are there, section rule 4. My lord, I will take it in detail to my lord. So there is a very detailed.
Which
thing
are
is
the
there.
questions of law?
My lord, the tribunal votes in my favor, but what it says, question is very limited. What it says is, department was aware of all this from the beginning. So it could not have taken action by extending the extended period of limitation. My lord, in case of suppression, fraud and willful misstatement, time is extended up to 5 years to initiate action.
1 year or 5 years?
1 year is a normal period. 5 years is an extended period of limitation in case of suppression, fraud, etc.
That is
11A.
section 11A 3(2).
Yes.
Read that. Let us see. Yeah. Three, two now. ಬರೆದಿರಲ್ಲಿ 3 Roman small 2. ಅದೆಲ್ಲಿದೆ ಇಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಇಲ್ಲ. ಯಾವ ಇಯರಿಗೆ ಇದು ಹಿಂಗೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಟೈಪ್ ಆಗಾಗ ಚೇಂಜ್ ಆಗತ್ತೆ ಏನು?
ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಯಾವ ಇಯರಿಗೆ?
I just but money. Lost my 4. 11A. Page 22. 4.
11A 4. ಮತ್ತೆ 3 ಅಂತ ಬರ್ತಿಲ್ಲ. 11A 4. A, B, C, D,
yes,
E ಇದೆ.
The 4 ingredients. Any one of these ingredients is satisfied.
Fraud, collusion, any willful misstatement or suppression of facts, contravention of any of the. ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ ನಿಮ್ದು?
On suppression.
In suppression.
They have suppressed this, my lord. This cross model discounts were offered. This was found detected.
It should be disclosed ಅಂತ ಎಲ್ಲಿದೆ ರೂಲ್?
ಅದು ರಿಟರ್ನ್ ಅಂಡ್ my lord ಇದರಲ್ಲಿ they should disclose the true transaction value
ಅಂತ ಇದೆಯಾ?
ಇದೆ.
ಅಡ್ಮಿಟ್ ಮಾಡೋಣ ಈ ಕ್ವೆಶ್ಚನ್ ಮೇಲೆ. ರಿಕ್ವೈರ್ಸ್ ಕನ್ಸಿಡರೇಷನ್. ಇದು ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಷ್ಟೇ ಅಲ್ಲ, ಇದು something if it is more than that then it requires consideration.
My lords, may I a copy of the appeal mechanism
Person.
and can be listed after 2 weeks.
ಅಲ್ಲಿ ಇನ್ನೊಂದು ಮಾಡ್ಬೇಕು.
I'll give
ಈ ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ
please
ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ದೇ ಶುಡ್ ನೋ ದಿ ಕ್ವಶನ್ ಆಫ್ ಲಾ. ನಾವು ಬರೀ ಅಪೀಲ್ ಮೆಮೋ ಕೊಟ್ರೆ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರು?
ತಮ್ಮದೇ ಆರ್ಡರ್ ಇದೆ.
ಇದೆ ನಾನು ಮಾಡಿದ್ದೇನೆ, ನಾನು ಯಾರು ಫಾಲೋ ಮಾಡಿ
ಕೇಸಲ್ಲೇ ಮಾಡಿ.
ದಟ್ಸ್ ವಾಟ್
ನನ್ನ ಕೇಸ್
ಎಲ್ಲ ಕೇಸ್ನಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅದು ಆಕ್ಚುಲಿ.
I'm giving the furnishing the copy to my
Lords, may kindly give us a week's time, my lords.
ಅದಕ್ಕೆ
For this.
ಇದಕ್ಕೆ ಅಡ್ಮಿಷನ್ ನಿಮ್ದೇನು ಕೇಳೋದಿರ್ತದೆ? ಬರ್ಕೊಳ್ಳಿ. The appeal is admitted. ಯಾವ ಕ್ವಶನ್ ಅದು?
23, 24 paragraph, my lord, only 2.
On the following substantial questions of law.
2 is important. 24 is most, my lord. Presumption of knowledge could be at page 21.
ನೋಡಮ್ಮ 23, 24. Yes, paragraphs. ಅವಲ್ಲ ಅಲ್ಲಿದೆ ನೋಡಿ. Following questions of law. ನೋಟಿಸ್ ಆಗಿಲ್ವಾ ಇನ್ನು?
ಇನ್ನು ಆಗಿಲ್ಲ.
issue notice, Shri so and so, the governor, volunteers to appear for the assessing. First time. Okay. Or copy kodi.
What is, sorry.
Yes.
An interim order has been challenged where bail was granted in writ proceedings. The petition itself where arrest has been challenged is yet pending consideration, where the very same arguments have to be advanced. So granting liberty, that petition itself, they can advance the very same arguments. Our entire case is that while assessing deficit in GST paid, two companies' assessment were clubbed and I was arrested. On which ground bail was granted, saying that two companies cannot be clubbed. It has to be assessed separately.
GST provisions and power to arrest ಇದೆ no?
Under section 69.
69.
69.
What? Read that. How courts have answered this question?
Malads, courts have identical to preventive detention. Malads, they've laid down the very same fundamental principles. Grounds of arrest must be handed over. Grounds have to be.
No, that is procedure. This is a question relating to competence of the single judge.
Please.
Whether bail can be granted by honorable single judge.
Please.
Under Article 226 for violation of GST provisions.
My lords, fundamentally, if the
where
guidelines...
one is arrested,
please,
because he committed an offense of violating the provisions of GST, their bail petition is moved.
Please.
Whether bail can be granted by the single judge
please,
or by the division bench is the question.
Please.
Adu helilo can be granted by single judge anta stay. How this question is answered?
I had relied upon a Gujarat High Court judgment where it laid down certain guidelines under which bail can be granted.
No, we're not on that. Who can grant the bail?
By the High Court, Malads.
By the High
Gujarat High
Court.
Court has laid down guidelines as to High Court also can intervene.
Single judge.
Single judge can intervene and lay down.
Paragraph. Read that paragraph. Single judge can grant bail. Or cannot grant bail. It all depends upon the state legislation. Under the
GST Act itself, while producing a person under arrest under section 69, the importance of valid, proper and exhaustive arrest memo should not be undermined. Every authorized officer shall act under the Act 2017 carrying out arrest must be clear that the preparation of an arrest memo is mandatory. At this stage, we state the guidelines issued by Supreme Court in DK Basu so and so.
You appear for petition?
I appear for appellate. My lord, but this matter was earlier filed by Amit Deshpande.
Now
it has been reallocated to me. My lord.
Ready in the matter?
Just a week's time, my lord. Next week, my apologies, my lord.
Shri so and so appears in the place of Mr. Amit Deshpande, who is semicolon. Deshpande, Mr. Deshpande is permitted to retire from the case.
One also.
Well, 1, 2, 3.
1, 2, 3.
ಅಲ್ಲ ಈ ಕ್ವಶನ್ ಫ್ರೇಮ್ ಮಾಡಿದಾರೆ ಅವರು
ಪ್ಲೀಸ್
ವೆದರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಕ್ಯಾನ್ ಗ್ರಾಂಟ್ ಬೇಲ್ ಆರ್ ನಾಟ್ ಈಗ ಇಟ್ ವೆದರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟೆಡ್ ಬೇಲ್ ನೌ
yes sir
that is being challenged
that is being challenged
this under GST Act.
Yes.
If appeal is which provision of GST Act?
69.
69. Power to arrest.
Power to arrest. 69 of CGST.
Where a person is arrested under subsection 1 for any offense specified, he shall be admitted to bail or in default of bail forwarded to the custody of the magistrate. If magistrate can grant bail, High Court judge cannot grant bail.
No, the
the
relevant
condition-
finding in single judge's order is at page 14 of the writ appeal.
ಆಯ್ತು ನೋಡ್ಕೊಂಬನ್ನಿ.
I'll just go.
Call next week. Now he is already granted bail.
Already granted.
Already.
Call after 2 weeks.
That again be disposed.
Covered by judgment.
Covered a simple issue is, my lord, what is the, my lord, the application filed by the SSC petitioner, my lord, under the Vivad Se Vishwas scheme came to be.
What? Ha.
The issue is, my lord, what is the disputed tax for the purpose of availing Vivad Se Vishwas?
Ha.
My lord, without going into the Vivad Se Vishwas Act, my lord, I will just bring my lordship's notice certain facts, which would be essential to come to the conclusion what is the disputed tax at the point of time. My lord, certain additions came to be made. My lord, the question before the learned single judge is in, my lord, page number 18.
Question that if you arise for consideration. Quantification of tax arrears in respect of disallowance under
40A1A for the purpose of availing the scheme. My lord, I'll come to the facts. My lord, facts are quite simple.
Ah.
My lord, certain additions came to be made under section 40A1A. My lord, without going into the merits, because we are concerned, what is the tax
arrears.
ultimately due for the purpose of the
That is tax
scheme.
arrears.
Yes, tax arrears.
My lords, it's disputed tax
Disputed-
is the point for my lord's
disputed
kind
tax
consideration.
at the point
Disputed
of
tax is defined also.
It's exact. It's defined.
certain, my lord, additions came to be made under section 40A1A at rupees, my lord, 80 crores.
In a case where any appeal or writ petition or appeal petition is pending before the appellate court, the amount of tax that is payable by the appellant if such appeal or writ petition was to be decided against him. In case appeals pending before only equitable priority. And the disputed tax means the income tax, including surcharges payable by the petitioner if the appeals filed with the revenue were to be decided against the petitioner.
My lord, A may be
Exactly.
seen, my lord, what is important next? Capital A in brackets.
40 small a I.
Either ಕೆಳಗಡೆ ಅಲ್ಲ I'm
A.
referring page number Inc 19 para 14 ನ ಮೇಲೆ A ಇದೆ capital A.
Ah.
In a case where any appeal, writ petition or special leave petition is pending before the appellate forum, as on the specified date, the
The
amount
amount
of
of tax that is payable by the appellant if such appeal or writ petition or special leave petition was to be decided against him.
ಅಷ್ಟೇ. So,
Step point.
ಅಷ್ಟೇ point. My lord, I'll come to the facts, my lord, in about 5 sentences.
Ah.
My lord, addition came to be made under section 40A1A. My lord, making a addition or disallowance of rupees 80 crores. I'm rounding the figures. Then, my lord, in the first appeal,
Yes.
the first appellate authority deleted a part of the additions.
Yes.
Now, the SSC files an appeal before the Income Tax Appellate Tribunal. My lord, against the portion which was retained or sustained.
Yes.
However, my lord, the facts, revenue did not file an appeal
So it had attained the finality.
to the my lord, that.
The learned judge just said that, therefore I said. Yes.
Then, my lord, the tribunal granted relief on the entire edition.
Appeal was filed only as far as the first contention of the petitioner is concerned, and the same are pending adjudication. However, the said appeals before the Bombay High Court are not in relation to the second contention. Hence, insofar as disallowance under 40AI, the disputed tax which is subject matter of departmental appeal before the High Court is as under. Correct ಇದೆ ಏನು ತಪ್ಪಿದೆ ಇದರಲ್ಲಿ?
No, we are taking a contention, my lord, the whole amount should have been taken as the disputed tax.
ಹೆಂಗೆ? How?
That's all.
Intra-court appeal is dismissed, broadly agreeing with the reasoning of the learned single judge.
Great law.
Yes. I heard Sri so and so and senior panel, senior counsel appearing for the assessing.
May I request for separate orders, my lord?
All right.
ಎರಡು ಒಂದೇ, ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ, 2 ವರ್ಷಕ್ಕಿದೆ ಅಷ್ಟು ಸೇರಿ.
2 ವರ್ಷಕ್ಕೆ.
All
Separate.
separate. ಅವ್ರಿಗೆಲ್ಲ ಫೀ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಸಿಗ್ತದೆ. ಅದ್ ಕರೀರಿ. All. ಮಧ್ಯಾಹ್ನ ಬರೋಣ. Okay. We'll come in the afternoon, please. Yes.
ಅಲ್ಲ ನನಗೇನಿಲ್ಲ, ಅಭಿನವ್ ಬರ್ಬೇಕಲ್ಲ. ಏನ್ ಬಂದ್ರು ಮತ್ತೆ ನೀನ್ ಏನ್ ಮಾಡಿದೀರ ವಿಡಿಯೋದಲ್ಲಿ ನೋಡ್ಕೊಂಡ್ ಬಂದು ಹೇಳಿ ಅಂತಂದ್ರೆ ಮತ್ತೆ ನಾನು ಫೈಲ್ ತರ್ಬೇಕಲ್ಲ. ಕೇಳಿ ನೋಡಿ.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
44 ಮುಗೀತು. 44 ಮುಗೀತು. ಎಲ್ಲಿ ಅಲ್ಲೊಂದು 10 ನಿಮಿಷ ಪಾಸ್ವರ್ಡ್ ಹಾಕ್ಬಿಟ್ರಲ್ಲ ತಾನೆ. ಏನಪ್ಪ
ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿದ್ದ ಮೆಮೋಸ್ ಹೋಯ್ತಾ? ಮೆಮೋಸ್ ಹೋಯ್ತಾ? IPR ಅಲ್ಲ GM.
ನೋಡಿ ಎಲ್ಲಾದ್ರೂ ಬ್ರಾಂಚ್ ಅವ್ರು ಹೋದ ಕಡೆ
ಅಗತ್ಯನೇ ಇಲ್ಲ. ಇದನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡಿಬಿಡಿ.
ಇದರಲ್ಲಿ ಬೋಂದು ರಾಮಸ್ವಾಮಿ ಕೇಸಲ್ಲಿ there were 6 parameters that were required to be observed by the committee.
ಕೊಡಿ. ಹಾ ಹೇಳಿ.
My only request is that, my lord, both matters, my lord.
ಅವನೇ ಯಾದಕ್ಕೆ ಅಂತ ನಿಮ್ಗೆ ಏನಾರ ತೊಂದರೆ ಇದ್ದುಕೊಂಡು ಅಂತ ಅವತ್ ಬೇರೆ
ಅಲ್ಲ.
ಇದನ್ನ ನೋಡೋಣ ಅದು ಏನಿದೆ ಅಂತ ಅನ್ಕೊಂಡು
ಸರಿ.
ಅಲ್ವಾ?
Yes, man.
ರೆಡಿ ಇಲ್ಲನೋ?
Ready, I know the facts of the case.
ಹೇಳಿ ಏನ್ರ ಅಂತ ಇತ್ತು ಅಂದ್ರೆ we will come to your assistance. ಸುಮ್ನೆ ಟೈಮ್ ಕೊಟ್ಕೊಂಡು ಜನ ಎಲ್ಲ ಮೊದ್ಲೇ ಬೈತಾರೆ ಎಷ್ಟು ಮುಂದೆ ಹಾಕ್ತಾರೆ ಕೇಸ್ಗಳನ್ನ ಅಂತ.
Even in that
ಬೇಗ
matter, my
ಮುಗ್ಸೋಣ.
lord, senior counsel, Mr. Udayawalla had argued the matter in that case.
ಹಾ
So even these matters are also, my lord, requires elaborate argument, how the parameters are to be.
ಎಷ್ಟು ನೋಡಿ ಹೆಂಗ್ ಟೈಮ್ ಎಷ್ಟಾಗ್ತದೆ ಗೊತ್ತಾ? ನಾ ಇದ್ರ ಸಲುವಾಗಿನ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನಾವು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಇಟ್ಕೊಂಡ್ವಿ ಮುಗಿಸೋಣ ಅಂತ ಅನ್ಕೊಂಡು. All this matter along with the WP number so and so.
Please, one request. In those matters,
Different,
parameters are different. Here is a parameter where he claims that his land is a nursery land. And on that ground, he wants to seek for a deletion of the land. What is a nursery land? How it should be considered is already dealt by your lordships.
and it is upheld by the Supreme Court now.
Yes, your lordships have held as to what land can be considered as a nursery land. Here, no documents are produced. They are on a different footing that, Lord, their adjacent lands were deleted on some of the other protections.
ನಿಮ್ಮ ಗ್ರೌಂಡ್ ಏನಿದೆ ತೋರಿಸಿ.
There are 2 parameters which we relied upon, my lord. Out of one parameter, my lord, is that adjacent lands have been deleted from the purview of acquisition. So therefore, my lord, my land is has become a pocket land or an island. So therefore, that is one of the parameter. Another parameter is that, my lord, that there was a nursery as on the date, because one of the parameters in the Bondu Ramaswamy case is that, my lord, where the lands are where there are nurseries, my lord, in the land, such lands are to be deleted from the purview of acquisition.
ಅವು ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಅನ್ನು ಮಗ್ಲಾಗಿನ ಲ್ಯಾಂಡ್ ಇಲ್ಲ. ಕಮ್ ಟು ಪೇಜ್ 20. Para 21.
Please, man. Committee was not justified in answering point number 2 and 3 in the negative. The scheduled property would squarely attract parameter F of the division bench of judgment for the reason that the lands adjoining the scheduled property, that is a portion of land in survey number 91/1B, a portion of land in survey number 94/3A, survey number 98/3, wrongly shown as government land, though the same is a private land belonging to one Dr. K. Veerappa Gowda and others, and other survey numbers are all denotified from acquisition. Further, the lands in survey number 91/7/1 and 97/2 are fully built up area, and therefore the same cannot be acquired. As such, when all the lands adjoining the petitioner's land are dropped from the purview of acquisition, and few other lands which are either fully developed or built up, the petitioner's lands are also to be treated on par with the lands that are dropped from the purview of acquisition, and the petitioner's lands cannot form a contiguous land for the purpose of formation of layout. As such, the petitioner's lands were required to be dropped from the purview of acquisition. The committee, except for stating that the scheduled property has neither become an isolated small pocket nor have they become island, has not taken into account the denotifying of the aforesaid lands in and around the scheduled property. There is no equal treatment in applying parameter F when it comes to the scheduled property of the petitioners and adjacent lands. As such, the report of the committee suffers.
ರಿಪೋರ್ಟ್ ಆಫ್ ದಿ ಕಮಿಟಿ ಎಲ್ಲಿದೆ?
My lord, report of the committee, my lord, is at Annexure L, Annexure K, page number 98. My lord, we have produced RTCs, my lord, right from the year 1980.
They are doubted.
They have doubted the RTC.
No, how you became the owner of the property?
My lord, I have purchased this property, my
Where
lord.
is the sale deed? ಈಗ ಕಮಿಟಿ tenure has expired.
No, committee is.
ಇದೆಯಾ ಇನ್ನು?
ಇದೆ.
Committee ಇದೆ. Various matters, my lord, pursuant to the judgment of the learned single judge, all the matters, my lord, challenging the acquisition proceedings were referred to the committee. My lord, where, my lord, the committee was only required to look into whether the lands will come under the parameters, that is 6 parameters laid down in the Bondurama.
ನಿಮ್ದು ಬೊಂಡುದಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ತದೆ?
Namdu Bondurama Swamila, there are 6 parameters, out of which I have taken up a contention that if adjacent lands are dropped from the purview of acquisition, such lands are to be dropped from acquisition ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನಂದುನು adjacent lands are dropped from the purview of acquisition ಅಂತ I have been able to demonstrate.
All right, we'll give you an example now. ಒಂದು 100 acres land ನಾವು ತೊಗೊಳೋದಿದೆ.
Please,
ಆಯ್ತಾ?
please.
ಮಗ್ಲಾಗಿಂದು ರೌಂಡ್ ಇರುವಂತದ್ದು ಒಂದು 10 acres ನಾವು ಡ್ರಾಪ್ ಮಾಡ್ತೀವಿ.
Please.
ಅದನ್ನ ಡ್ರಾಪ್ ಮಾಡಿದ್ದಕ್ಕೆ ಎಲ್ಲದನ್ನು ಡ್ರಾಪ್ ಮಾಡ್ಕೊಂತ ಹೋಗ್ಬೇಕಾ?
ಅಲ್ಲ, ಎಲ್ಲದೂ ಬೇಡ. ನನ್ನ ಸುತ್ತಮುತ್ತ ಇರೋದು, I am able to show my north, my south, my east are dropped from the purview of acquisition by the very same BDA.
Is it true?
But
Otherwise, I
that
would.
had to be looked, what had to be looked into by the what was the matter for reference before the committee was whether the BDA in the year 2004, when final notification was issued, whether the lands adjacent to a particular land were not notified in the acquisition proceedings. It is not that, my lord, the BDA and the state government went on deleting 983 acres of a land. That is what was found fault with this honorable court, and said, my lord, instead of remitting the matter again back to the BDA and the state government to redo the entire process, committee was constituted. To the cutoff date for looking into the land, status of the land was as on the date of final notification. That is 2004. As on 2004, if the adjacent lands were not there in the notification itself, then such lands were entitled for deletion of the lands. But however, if they form a contiguous part and the part is needed for the formation of the layout, but they were not supposed to be deleted. Well, that is why 983 illegally, the learned single judge give the finding that in many of the cases, a small building in a entire survey number is considered to be an entire built-up property,
Only
and
to
such a
save
land
from
is
acquisition.
deleted. Yes,
Only to save from acquisition.
yes. That is why the committee had.
Idರಲ್ಲಿ why, see, when you doubted the RTC.
Yes.
You doubted RTC. Committee doubted RTC.
Committee. No,
Why it doubted RTC?
I don't appear for the committee, my lord.
No, anyway.
Yes, BDM, I appear for BDM. And insofar as the two contentions which were raised by the petitioner, but they have been answered, clearly answered by looking into the status of the land as on the date of final notification. Lord, may kindly take, Lord, may kindly take, Lord, page 111, para 11, Lord, of the committee's report. Please, we have heard the arguments of learned counsel appearing so and so applicant, and also the additional response. In light of the above, following points arise for consideration of this committee, whether as on the date of the preliminary notification 3/2/2003, the lands in questions were nursery lands, whether the adjacent lands have been dropped from the acquisition, if so, whether the lands in question have become small pockets of the land where comprehensive self-contained layout cannot be formed, whether the lands in question qualify for the deletion of the acquisition proceedings as per the parameters and the guidelines laid down in the judgment of division bench and that of the Honorable Supreme Court of India in Bandaram Swami's case. While answering, Lord, the point number 1, page 119, Lord, the committee answers these questions. May I, Lord, para 22.
During
the arguments addressed on 17/4/2023, the learned counsel for the applicants vehemently contended that the late Nanjappa, the owner of the land in question, was running a nursery in the lands in question as on the date of preliminary notification. As such, the land in question were nursery lands. To support this contention, he relied on RTCs for the year so and so in respect of the land in question issued by the village accountant of the concerned village, wherein it is mentioned as a nursery. In this regard, the learned counsel further relied upon a copy of the objection submitted by Sri Nanjappa to the acquisition before
24. Come to 24. Relying on the RTC issue.
Relying on the RTCs issued by the Tahsildar for the year 2001 and 2002 in respect of the land in question, it was contended on behalf of the BDA that entries in these RTCs which have a presumptive value clearly indicate the crop grown in this land were Nilgiri trees, and there has been no mention of the existence of a nursery. It was further contended that the nursery existed in the lands in question as on the date of preliminary notification, and said fact had been reflected in RTC for the relevant years prior to the date of preliminary notice.
In the nursery, there is nothing in the RTC as to the nursery.
Nursery ಅಂತಾನೆ ಇದೆ.
ಎಲ್ಲಿ ತೋರಿಸಿ. Where is that? ನಮ್ದು ಡಿವಿಷನ್ ಬೆಂಚ್ ನಂದು 4 ಸಾಹೇಬ್ರದ್ದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಇದೆ ಸರ್. Annexure C, page 18 is the RTC.
Annexure C, page 18.
Sir.
Tengu nursery.
Mau Tengu nursery Sapota. Nursery Sapota, it is my land. It is entered, but as per the Google the map, as on that day, what was taken is the Nilgiri Topagitu. That is what is.
What it does not fit into the definition of nursery.
Nursery field. Right. Your lordships have held that it should be registered. Lordship may kindly take para 22 of your lordship's order.
This is affirmed by the Supreme Court now.
Yes.
22.
The Ma'am Lord, page 57. Lord. The same swan song is projected by the petitioner in this case on hand as well. In order to buttress the submission, several photographs are placed naming the nursery as so and so. These photographs do not inspire our confidence in contrast to what the learned counsel for the BDA has placed, as they were overwhelming piece of evidence depicting the status of the land of the petitioner. The learned counsel for the BDA places the status of the land in 2008. At the time of acquisition, it is vacant. Subsequently, at the time of inspection, it is vacant. Google Earth images taken on so and so and so and so depict that the land was vacant. Same goes of the images taken on so and so with respect. Lord, may I skip this? To our pointed questions, the learned senior counsel for the petitioner, learned senior counsel would submit that the land is being used as a nursery has not been subject matter of any registration with the Indian Horticulture Board. No farming activity is undertaken. There is no livestock, no compost or waste management is processed, nor biogas is generated. There is no counseling session with regard to the development of a plants at the nursery at the time undertaken by this petitioner. A nursery, in our considered view, must be the one registered with the Indian Horticulture Board, the registration being made subject to renewal from time to time on a due inspection by the competent authority. That is still that it still runs as a nursery. The traits of using the land as a nursery as obtaining under any regulatory regime of the activities that are found by the committee in the nursery that is exempted from such acquisition. We thus fail to understand how can such land which does not bear any of the characteristics of a nursery be exempted from acquisition. In our considered view, the government order dated so and so was a case specific that is being used or misused to get the exemption from the acquisition till this day. The learned so and so for the petitioner places reliance on the said government order 1/1987 and beyond. It is right law that the government order circular, here you are also interpreting as to whether based on that 1/1987, whether the lands could be exempted from the acquisition proceedings.
When, as on which date you took Google map?
Lord, it was taken on 1/1. Sorry. Lord, 25/9/2002.
That's the cutoff date.
As on that day, Lord, 25/9/2000. We have taken several Google Maps, Lord. Lordship may kindly take page 107, Lord.
107.
Yes.
Yes, written response on the plea in
Written
the form of
response.
affidavit.
In that, my lord, para 2, my lord, that the satellite image captured on 25/9/2002 showed the existence of a tree plantation and there was no existence of a nursery in the lands. That the Mahajar report dated 14/8/2003 shows the existence of only stone slab compound wall around the land in question. That the satellite image captured on 5/11/2003 shows a complete deforestation of a eucalyptus plantation from the lands. That the satellite images captured on 3/2/2004 showed the dry condition of the lands without any trees and plants. That the Mahajar report dated 26/4/2004 showed that the land was vacant and surrounded by a stone slab compound wall. That the site inspection report so and so showed that the land in question was a vacant land and there are no existence of a nursery in the said lands. Soon after the publication of a preliminary notification, the landowner removed the entire eucalyptus tree plantation and erected an all-round stone slab compound and kept the lands dry, and that the land owner has given a false statement that the nursery existed even prior to the date of preliminary notification. That the lands in question were not used for a nursery purpose at any time prior to 2003, and they were actually used for eucalyptus plantation as on 3/2003. That after the issuance of the final notification in the year 2004, awards were placed. This is with regard to not the acquisition proceeding. That is with regard to the nursery lands placing of the dock.
What about the dropping of other surrounding lands?
Lordship, kindly take that. Lord, page 127. Learned counsel for the applicants. Contended that the land bearing so and so.
98.3 located on the western side, so and so, so and so.
Delete it from there. First. But the committee is finding at.
But they were fully developed lands.
Yes. Committee is finding at page 37, para 37. No doubt. Land bearing number 9853 lying on the west and survey number 91/2 has not been notified for acquisition, while land bearing number 91/3A, which is lying to the south of 91 to the west, has been subsequently deleted from the acquisition under redo exercise. However, the land bearing so and so to the east land has been acquired. Similarly, large tracts of the land in survey number 90 par so and so have been acquired, and according to BDA, layout has been formed in those lands. Similarly, land bearing number so and so lying immediately on the north of survey number 91/2 and 91/1A so and so, which are located to the north of survey number 91, have been acquired. From this topography, it is clear that the land in question are surrounded by acquired lands on the three sides, and thus they have not become small and isolated focus as sought to be contended, in view of the fact that the BDA has already formed layout in the land bearing number so and so, lying to the south of so and so. The lands in question can be conveniently used for the form of contiguous layout, along with the layout already formed in the lands lying to the south of so and so. The layout that may be formed in the lands in question can easily be integrated with the layouts already formed in these lands lying to the south of so and so.
Yes, brother. One is, it's a nursery land.
Please, ma'am.
So to substantiate that it's a nursery land,
Please, ma'am.
you have to show the material.
Please, ma'am.
And your lines upon the entries in the revenue records, nursery, no presumption would arise.
No, as per their own report, there existed a nursery as on the date of final notification.
Where is that?
May not please see, may not. Before that, may not, may I just point out to my lords. Page 115, my lord. May I kindly
115.
request 115. It's a report of the committee. Wherein, my lord, at the third para, my lord,
the
You see judgment.
judgment of Bundu Ramaswamy
Huh.
clearly stipulates, my lord, 6 conditions.
Correct.
It says, my lord, as on the date of final notification is what the
Correct.
committee has to take into consideration,
Yes.
not the subsequent development.
Correct.
So the final notification was in the year 2004.
Ah.
So as on 2004, if I am able to demonstrate that, my lord,
There
that
was
there
no-
existed a nursery, or that, my lord, subsequent, the adjacent lands were dropped from the purview of acquisition, then I am through, my lord.
That nursery should be as per our judgment.
Please, my lord. My lord, I have placed on record documents which are, my lord, not taken into consideration by the committee. That is my one, another grievance.
What are the documents?
My lord, I have placed on record, my lord, the purchase of plants as well as, my lord, machinery. There was a borewell. All these, my lord, aspects goes to show that there was a nursery.
Purchase of lands, other sale.
Purchase of plants.
Purchase of plants.
Plants.
How you, where you purchased it, when?
Yes,
how-
I'll just.
ಅಲ್ಲಿ ನರ್ಸರಿ ಇತ್ತು ಅಂತ ತೋರಿಸ್ಬೇಕು. ಪ್ಲಾಂಟ್ಸ್ ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರ್ಬೋದು.
ಅಲ್ಲ.
But as on that date,
Yes.
nursery existed on the land. That you have to demonstrate. You might have bought for nursery items, but where did you go land them? We do not know.
ಅದಕ್ಕೆ Google photos.
ಅದು ತೋರಿಸಿ.
They say that, my lord, that.
Google photo ಹೋಗಿ.
No, please. I'm sorry, my lord, I have one copy. I'll just.
ಪಡಿ.
And to correlate this, my lord, their own report goes to show that the given by Special Land Acquisition Officer who inspected the property in
How
question.
when he was inspected?
ಅದು ನನ್ನ ರಿಟ್ ಪೇಪರ್ಸ್ ಜೊತೆ ಹಾಕಿದ್ದೀನಿ.
ಅಲ್ಲ, when, what is the date of his report?
2010, he has filed the
but-
report, but he has dated back as on the date of notification, what was the condition of the land,
How he
nature
will-
of the land.
How he will know?
He says that, ಅದೇ, annexure B,
ಒಂದ್ ನಿಮಿಷ ರೀ.
please,
ಈಗ ಇದ್ರಲ್ಲಿ ತೋರಿಸಿ ನಿಮ್ಮ ನರ್ಸರಿ ಇತ್ತು ಅಂತ.
please, my lord, the first photograph, my lord, is of the year 2002. That is my land, where, my lord, the plants are existing. In their photo, my lord, they show a barren land. In the second photo, my lord, it is of the year 2004. Of course, the third photo is of 2008, which is not of consequence, my lord, at all. For my purpose, I have,
Now what you are doing in that land?
my lord, it's empty. It's empty. Oh,
Therefore,
as on today, my
it
lord,
should be as on the date of notification, it should be nursery.
ಅವಾಗಿತ್ತು.
It should continue to be nursery.
Continue ಮಾಡೋದಕ್ಕೆ, they came and, my lord, interfered with my possession. BDA came with JCB. That is why, my lord, I have placed on record right from, my lord, 2010. There is an interim order protecting my interest in respect of the property. I have placed that also on record.
ನಿಮ್ ಫೋಟೋಗ್ರಾಫ್ ಎಲ್ಲಿದೆ? As on that particular 2004. ಈ ಗೂಗಲ್ ಮ್ಯಾಪ್, ಗೂಗಲ್ ಫೋಟೋಗ್ರಫಿ.
I'll check it. I'll check.
ಅದಿಲ್ಲ.
That is with the committee, not, I'll have to secure it.
ಬಟ್ ಅದನ್ನ ಕೊಡ್ಬೇಕು. ಈಗ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, ನಂಗೆ is. The fact that, my lord,
Right from 2006, my lord,
ಇದನ್ನ ಫೋಟೋಗ್ರಾಫ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲನು ಕಮಿಟಿಗೆ.
now we have placed that on record, but, my lord, they, with all utmost respect, my lord, they'll rely upon the photographs, what they want to.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ಫೋಟೋಗ್ರಾಫ್ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಎಲ್ಲಿದೆ?
Para 32 of the committee's report,
ಪೇಜ್
125. But in the light of this, I'll read with regard to, my lord, these documents produced. What documents?
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಬಗ್ಗೆ ಇಲ್ಲ ಇದರಲ್ಲಿ.
Photograph
That
ಬಗ್ಗೆ
drop in
ಎಲ್ಲಿದೆ?
question immediate so and so, and the point of, apart from the copies of the RTCs produced along
ಅದು
with the
ಬಿಡಿ,
objection,
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
no other documents is produced ಅಂತ committee ಅವರು ಬರೀತಾರೆ.
ಇಲ್ಲಿದೆ ನನ್ನ ಹತ್ರ acknowledgement ಇದೆ.
ಏನೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಿ?
Photographs, ತೋಟಗಾರಿಕೆ ಇಲಾಖೆಯಿಂದ
ನೋಡಿ
ನಾನು-
ಒಂದ್ಸರಿ.
It was also served, my lord, without serving the,
No,
I will not
I'll not be,
entertain.
I'll not be able.
ಅವ್ರು ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ?
ಅಲ್ಲ, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ, ಬಟ್ ಕಮಿಟಿ ಅವರು ಆ ತರ ಬರೀತಾರೆ, ನನ್ಗೆ ಗೊತ್ತು. ಐ ವಾಸ್ ನಾಟ್.
ಅಂಡ್ ರೆಮಿಟ್ ಮಾಡ ಕಮಿಟಿಗೆ ರೀಕನ್ಸಿಡರ್ ಮಾಡಿ ಅವ್ರು ಕೊಡೋ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಏನೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಪ್ಲೀಸ್.
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಈಗ ನಮ್ಮ ಅದ್ರ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಎಲ್ಲ ತೋರಿಸ್ತೀರಾ?
I'll secure that instruction.
ರೆಕಾರ್ಡ್.
Committee ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಅವ್ರು, ಯಾಕಂದ್ರೆ we have no, the state appears for committee. We appear only for BDA. ಅಲ್ಲ, ನಾವು ಆಸ್ ಎ ಪ್ರೆಸೆಂಟರ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಪ್ರೆಸೆಂಟ್ ದಿ ಸ್ಟೇಟಸ್ ಬಿಫೋರ್ ದ ಕಮಿಟಿ. ಕಮಿಟಿ ಅವರು ಇದೇನಿದೆ ನೋಡ್ಕೊಂಬಂದು ಹೇಳಿ, ಇದೇನ್ ನೋಡ್ಕೊಂಬಂದು ಹೇಳಿ ಅಂದಾಗ we'll have to give them a report because that is what has been directed.
ನೀವು ಆಸ್ ಆನ್ ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್
Please,
ನೀವು ಗೂಗಲ್ ಮ್ಯಾಪ್ ಗೂಗಲ್ ಫೋಟೋಗ್ರಫಿ ಮಾಡ್ಕೊಂಡು ತೊಗೊಂಬನ್ನಿ.
ತೊಗೊಂಬರ್ತೀನಿ ನಾನೇ.
ಇವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಿ ಮಿನಿಮಮ್ ಮಟೀರಿಯಲ್ ಇದೆ.
Please,
ನಿಮ್ದು ತೊಗೊಂಬಂದು ತೋರಿಸಿ.
ಆಯ್ತು.
We'll decide the matter here itself.
please.
Heard in part. First off, learned counsel appearing for the petitioner complains that despite production of evidentiary material such as Google photographs, comma, the committee says that no such material was produced. First off, he has
No such material.
shown the photographs to us this day. To vouch that as on the relevant point of time, that is 2004, when the final notification was issued, there existed a nursery in the land in question, and that nursery could not be continued because of intervention of the BDA.
And I was protected by interim orders of this
First.
court all throughout.
He also submits that throughout he had the protection of interim orders at the hands of writ courts. First off, learned senior panel counsel appearing for the BDA controverts the above submission of the petitioner and submits that he would instruct his officers to undertake Google photography for the relevant period and produce the same on the next date of hearing. First, learned AGA appearing for the one-man committee.
Three-man committee.
Three-man committee submits that she would secure the entire record of the proceedings on the next date of hearing and make submission. First, call this matter. One date ಹೇಳಿ ಯಾವತ್ತು ಬೇಕು?
Any day.
ಹೇಳಿ ನೀವು ಹೇಳಿ. ನೀವು ಯಾಕಂದ್ರೆ ನೀವು ಗೂಗಲ್ ಫೋಟೋಗ್ರಫಿ ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಅದಕ್ಕೆ.
ಆಯ್ತು.
ಯಾವ ಡೇಟ್?
Next week ಅಲ್ಲಿ any date, any convenient date.
2 weeks, my lordship, because.
2 weeks. On
My lord, may I request 6th to 10th of February,
You
there
are
is
not
some
there.
inconvenience. Please,
before that I will have that.
please, my lord. Or after.
5th ಬೇಡ 3rd ಹಾಕೊಳ್ಳಿಕ್ ಬರ್ತದಾ? ಹಾಕೋಬೋದಾ? 3rd of February. So that if you need some time, we can
Yes.
accommodate you that way also
Please, please.
for further hearing.
At
ಅವತ್ತು
the
ತೋರಿಸ್ಬೇಕು.
entire annexure J is what is their request before the honorable committee.
We'll consider.
In this, no photographs I see. They say only the satellite images they are saying. Photographs as such, my lord, they also don't say.
Anyway,
anything.
ನಾವು ಈಗೇನೋ ಹೇಳಿದಾರಲ್ಲ ಅವರು,
Yes, yes.
ಈಗ ನಮ್ಮ ಉದ್ದೇಶ ಏನು? ನಿಜವಾಗಿಯೂ ನರ್ಸರಿ ಇತ್ತು ಅಂದ್ರೆ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡು. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ವಾ?
Nursery ಇದ್ರುನು
It should
will not-
continue as on the date.
it should continue as a nursery in eternity. If not, it will revert back to the as it revert back in the acquisition ಅನ್ನೋದು. That is what is the discussion
Observed by
of your lordships in the division bench.
No, for
Now
me
the-
to, my lord, continue.
ಅಲ್ಲ ಮೊದ್ಲು ಇದನ್ನ ತೋರಿಸ್ತೇವೆ.
It is a,
ಇದೆ ಅಂತ ತೋರಿಸಿ.
ಇದೆ ಅಂತ ತೋರಿಸಿದ್ರು ಅದು ನರ್ಸರಿ ಆಗಿ ಉಳಿಬೇಕು.
ಉಳಿಬೇಕು.
My lord,
ಅಂಡರ್ಟೇಕಿಂಗ್ ತೊಳಿಕ್ ಬರ್ತದೆ ಏನೋ ಒಂದು ಮಾಡೋಣ ಅಂತ ಇಷ್ಟಕ್ಕೆ ತೋರಿಸ್ತೇವೆ.
it is at their interference, my lord, I could not continue the nursery. That is one aspect of the
ಎಲ್ಲಿ
matter.
ತಗೊಂಡಿರಿ ನೀವು ಆ ಕಂಟೆನ್ಷನ್? Where have you taken up that contention?
The contention, my lord, the interim orders, my lord, that itself will speak of this honorable court, where, my lord.
Otherwise the entry order ಕೊಡೋ ಪ್ರಶ್ನೆನ ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಬರ್ತಿರ್ಲಿಲ್ಲ.
ಆ entry order ಆದ್ಮೇಲೆ ಎಲ್ಲಿ ಮಾಡಿರಿ? ಎಲ್ಲಿ
2020 I have secured an interim order before this court, wherein they came, my lord, and started digging the.
ಆಯ್ತು. ಎಂಟ್ರಿ ಆರ್ಡರ್ ತಗೊಂಡು ನೀವು ಪ್ರೊಟೆಕ್ಷನ್ ಮಾಡಿಕೊಂಡ್ರಿ. ಅದಾದ್ಮೇಲೆ ನರ್ಸರಿ ಎಲ್ಲಿದೆ?
No, they have destroyed they came with JCB, they destroyed the entire land. I have placed those photographs also on record in 16 numbers, which will clearly goes to show, my lord, I could not, my lord, really continue the process of nursery there. That was the state of affairs. My lord, they started putting up my lord, digging the land, excavating the entire land and all those aspects, my lord. My lord, even
ಮತ್ತೆ ಹಂಗ್
if-
ಮಾಡಿದ್ರೆ ಹೆಂಗ್ ನರ್ಸರಿ ಉಳಿಯುವುದಿಲ್ಲ.
ಅಲ್ಲ, ಅದು ಸಾರಿ.
even otherwise, my lord, one more submission. Sorry, one
Not
more.
if it is pleaded, not then I would have said something about it. But even otherwise, no. But generally we are known, from BDA is known that we, in spite of everything, Lord, we don't go and take possession. But here the case is not that, Lord, BDA goes and takes possession.
But
without the-
My lord, 2020 secured.
ಸ್ಟೇ ಆಫ್ ಡಿಸ್ಪೊಸಿಷನ್ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರು. ಎಲ್ಲಾ ಕಡೆ ಆರ್ಡರ್ ಆಗಿರೋದು ಸ್ಟೇ ಆಫ್ ಡಿಸ್ಪೊಸಿಷನ್ ಇರಬೇಕಾದ್ರೆ there is no question of we going in demolition. In Arkavati layout, you did not do anything is an allegation against BDA.
My lord, this
Despite
is
you had a
this
court
is the
order
land
backing you,
which
you
is
did not do anything.
almost 3 acres, my lord. It's not a small land. My lord, we placed all photographs on record along with the application seeking interim order. That is during the COVID period when they attempted to interfere. It is at that point in time, my lord, after taking note of the photographs and also the situation, my lord, this honorable court granted the interim order. My lord, another aspect of the matter is, my lord, even if I am unable to, my lord, satisfy my lords regarding the existence of a nursery as on the date of, my lord, preliminary final notification, my lord, the other parameter is always available to me. My lord, what the Supreme Court says, my lord, out of the 6 parameters, if I am able to demonstrate that I fit in at least in one of the parameters, also I am, my lord, I have clearly demonstrated as to how my adjacent lands are.
ತಿಳಿಸ್ಕೊಂಡು ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಇಯರ್
Please.
ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಕಾಲ್ ಆನ್. ಅದನ್ನೆಲ್ಲ ನೀವು ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
ಅದನ್ನೆಲ್ಲ ನಾನು ಮಾಡ್ತೀನಿ.
ಬೇಡ, ಇಂಡಿಪೆಂಡೆಂಟ್ ಇದೆ, ಅದೇ ಬೇರೆ ಇದೆ.